Call the meeting to order of the Sunshine Ordinance Task Force, 4:05 p.m.
This is the meeting of the Sunshine Ordinance Task Force for December 19, 2017. On the call, the roll. Member Eldon.
Present.
Eldon present. Member Josh Wolf.
Present.
Wolf present. Copra absent. Member Tesfa absent. Member Moss.
Excuse.
Here.
Member Tesfa is listed as excused. Member Moss present.
Present.
Member Kanata.
Present.
Kanata present. Member Fisher.
Present.
Fisher present. Member Hinsey.
Present.
Hinsey present. Vice Chair Highland.
Excuse.
Highland excused. Chair Wolf.
Present.
Wolf present. We have a quorum. There is one request. I'm not regarding our next item, the item immediately after the minutes regarding Thomas. Actually, yes, for item 3, there's unknown request. He is unable to make it at today's meeting. He did not request continuance or ask us to proceed. It will be up to us to decide how to proceed.
Okay, great. Thank you. All right, any adjustments, changes to the agenda? Seeing none. Okay, let's move on.
Next on the agenda, approval of the minutes from the Sunshine Ordinance Task Force, December 6, 2017 meeting.
Is there a motion to approve the minutes?
Motion to approve the minutes?
Second.
Moved by Member Moss, second by Member Hinsey. Any discussion, changes, edits? Seeing none. Public comment on the minutes.
I was here at that meeting, and I spoke on the Ray Hart's matter. It doesn't appear in the draft minutes.
Okay.
I didn't speak in support of him or in support of the respondent, but at the end, and it wasn't recorded.
It wasn't recorded on the
it
tape?
didn't. Oh, sorry, it didn't appear in the draft minutes.
Okay, we'll review the audio and make sure it gets included. Any other public comment? Seeing none, can we take this by acclamation? Seeing no objection?
With the proposed amendment, if I do find any changes regarding
Yes.
Mr. Bowe.
Please do. Okay, let's take that without objection.
The minutes is adopted without objection with Member Copra, Tesfa, and Highland being absent or excused.
Okay, next item, please.
Next on the agenda, item number 3, file number 17039, complaint filed by Thomas Bussey against the San Francisco Public Finance Authority for allegedly violating Administrative Code, Chapter 67, by failing to notice and conduct public hearings and failing to respond to requests for public records. I have provided a copy of the email that Mr. Bussey provided to me yesterday, stating that he could not attend today's meeting.
Okay, thank you. So members, we can either move ahead with this item or close it out. One thing I would offer in this is that there's been no respondent to this, since this is a body that's supposed to be shared by the school district and the supervisors. So supposedly it has not met, even though the law states its existence. And I don't, we can't compel people to have meetings or not if they're not organized or what have you. I think at this point the petitioner may want to address this with the supervisors directly, most notably the president of the board, or they might want to take it to another department or agency or authority that might have a little more enforcement power. I think this is it's one thing if they had met once and then didn't meet on a regular basis. That's one thing, because then we can identify who had attended. But there is no information that I could find, even on my own. Member Kanata.
I started reading through it, and there's a lot of information in there. But it also stated that there was a records request, and I couldn't find the request in the packet, nor who it was made of, but it did say there was a record request and records were not provided. So I don't know if it makes sense to get into it with neither party here.
Well, the problem is there is no party involved. The Board of Supervisors and the San Francisco Unified School Districts is not the respondent. There is no named respondent in this complaint, as this Public Finance Authority has not met, and there's nobody there to send a request to.
So through the chair, so there is no public finance authority at all, just the name? There's no people associated with it?
Supposedly, it's kind of there's some pro forma function that happens, according to Mr. Busey, at his testimony, that over the years when items that are referred to this particular body are brought forward, they're dealt with kind of in some sort of pro forma kind of way, where a meeting doesn't happen or something like that. It's just hard to find out because there's been no respondent. So, question is how do you want to adjudicate it? Member Fisher and then Member Moss.
Am I on? Am I on?
You are.
So if there's no way to respond to this, there's no way to adjudicate or do anything with it, as much as I hate to do this to a member of the public, I mean, our hands are tied on this. Don't we just close it out and say, we're really sorry, and maybe Victor has some other ideas who this person could talk to? I don't know city departments that well. I mean, that's posed as a question, is closing it out with our regrets.
Member Moss.
So if I'm reading this correctly, our city attorney doesn't believe that this body would come under our jurisdiction anyway. Am I reading this correctly, DC Cola?
Yes.
So, I mean...
Well, from my reading, because there are elected officials that represent the city, at least there's some... I would think there would be some responsibility because it does involve public money. I'm not quite sure whose money it is at this point because there's no respondent to answer. So that's why I think at this point, without the petitioner here, without a respondent ongoing, if the respondent wants to, reconsider our decision today or wants to kind of reissue the complaint in some other kind of way, if he finds more different information, then we can take it up then. But right now, I don't know how to move forward on this
Through the chair, Victor, did the complaint committee, did we find jurisdiction on this, or?
I believe they did find jurisdiction, but it was, it's still, it was questioned during that meeting, but
We found jurisdiction that the information was public.
Okay.
The question is whether it comes under the Sunshine Ordinance was the other question, and because there were representatives from the city on the body, that created the center, the focus of the question. All right, so what do you want to do?
Can I make a motion?
You certainly can.
I make a motion that we close this out.
I will second.
Victor, you're giving me
we can conclude it, but is there, do you want to put any reasoning behind this, that we don't have jurisdiction, or
Okay, how about I make a motion?
A reason why we're concluding it?
I make a motion we conclude it because we don't have jurisdiction. Is that going to fly, DCA Cola?
I'll second that.
Actually, Member Hensey seconded it.
Yes.
But she just rephrased it, so
Okay.
I wasn't sure if
That's fine.
Member Hensey was seconding the new version.
Okay, sure. Okay, moved by Member Fisher. If it's okay with Member Hensey, we'll make the second to Member Moss. I would say that I'm not quite sure that it's out of jurisdiction, but I think for the time being, until if Mr. Busey wants to bring it forward again and has a little more clarification, I'll step aside on that. Any other discussion on this? Move to public comment. Any public comment on this motion? Seeing no public comment. Anything else? Last words, please call the roll.
On the motion to conclude the matter due to lack of jurisdiction, Member Fisher.
Aye.
Fisher, aye. Member Moss.
Aye.
Moss, aye. Member Eldon. Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Tesfa, excused. Member Kanata.
Aye.
Kanata, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland, excused. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Please call the next item. It's not quite 5 o'clock yet, so we'll skip number 5. I think we can
Item
get through the
number
next
4.
one pretty quickly.
Reconsideration of complaint file number 17009, complaint filed by William Clark against Tom Cagney and the Arts Commission for allegedly violating Administrative Code, Section 67.5 and 67.7 by failing to comply with regulations for policy bodies and post agendas for the Community Working Group of the Arts Commission.
Are both parties here? Okay.
I do not see the representative from the Arts Commission present yet.
Okay. Mr. Clark, are you the primary? It says Mr. Dario. Oh,
Item 4.
Oh, I'm sorry. My bad. My bad. Sorry.
All been there.
Okay. All right. So this is a item that's coming back to us for reconsideration at the request of the petitioner. This will take the item to where we were in discussion just before the vote. And it will allow the petitioner who requested the reconsideration to provide any additional facts or evidence that might compel us to change our decision on this. So, Mr. Clark.
Excuse me. I have a cough. I sent some things in emails to you. I hope you all remember this case because we reached the point where I stated that the working group is a policy body based on the definition that's in the Sunshine Ordinance in Section 63. I think it is 4D. And I brought in last week a whole bunch of stuff, and the whole problem was whether or not the Arts Commission approved the working group by approving the working policy that they passed. And I sent you emails that were sent to me from the Arts Commission in which the Arts Commission stated that the working group was approved by the Arts Commission. I sent you the minutes from the committee meeting that where discussion was held on it, and I also sent you minutes from the Full Arts Commission where they passed the resolution on the consent calendar. So there really wasn't any discussion at the Full Arts Commission. It was passed on the consent calendar, and basically the one last email that I presented to you was the one that I received, in which it was sent to me in January 30th, in which the Arts Commission representative, Ms. Patterson, states that that in response to my question, the Full Arts Commission approved the work plan at its meeting on March 7th, 2016. The Commission approved the following relevant two resolutions. The first one I don't think is relevant, but the second one was the motion to approve the work plan and project scope statement related to Kate Faust evaluation and feasibility study reports. In response to your second question, does the Arts Commission take the perspective of the street artists on the community working group into consideration when deciding what the Art Commission is going to do in order to implement the work plan to modernize the street arts program? The answer is yes. We take the artist's perspective into consideration. So that right there, by their own admission, the Full Arts Commission created the working group when they created the working plan, and two, they admit that the working group is an advisory body because they take their advice into consideration. I also sent you last time copies of the working group minutes from 5 different meetings, and to show you some of the things that were discussed at those meetings and that were later approved by the full Arts Commission. And many of those things include changes in policy in the administration of how certificates are issued, how much they're going to be paid, and a lot of other things that were being discussed at that committee meeting that gave the Arts Commission the advice. So personally, I think that the issue at this point, this is like, the fourth meeting now on this, is the city attorney at the committee meeting, first committee meeting, we left that first committee meeting with the city attorney was going to give you advice on whether or not this working group did fit into the definition of a policy body. Last time we met, you asked for that definition from the city attorney, but he just advised you to do it on your own. And, all I'm saying is that the definition of a policy body is that it's any group that's initiated at the behest of a policy body, and it's any advisory group that's created by the initiative of a policy body. And since the Arts Commission is a policy body, and they created the working group, and the working group was an advisory committee, then therefore I suggest that it meets the qualifications for a policy body. And you've already rejected your previous motion, and the motion in front of you is whether or not it's a policy body, and did they violate Section 67.5, which states that every policy body must follow the rules of the Brown Act. And so I'm asserting that they are a policy body, and because they held secret meetings and violated, wouldn't let people tape record, wouldn't let people attend the meetings, that it does constitute a violation of 67.5. If you have any other questions, I'd be glad to answer them.
Okay, let's hear from the respondent.
Good evening, everyone. Kate Patterson from the Arts Commission. As Mr. Clark noted, this is, I believe, the third time we've heard this. So I don't have anything really additional to add beyond what we've already presented in the form of our letters and previous testimony. I'm happy to answer questions. I just will state again for the record that this was not a policy body, nor were these meetings secret. All information requested with regard to these meetings was turned over. Again, I'm here to answer your questions. Thanks.
Thank you. Okay, members.
I was persuaded the first two times, so I'm good.
Member Moss,
Yeah, no, I believe this is a policy body. Do we want to discuss first, or I can make a motion?
go for it.
I believe it is a policy body.
We are in disagreement.
So I should make a motion on it? Is that
If
where we
that's
are?
where, if
Or
that's where we are.
All right, so hold on a second. Let me just compose my thoughts here before I read it out, if that's okay. I believe we were looking at 67.7 and 67.5, if I'm not mistaken.
Let me, just as a point of order, Victor, did we have a motion on the floor? Did we have a motion on the floor for this case at the time?
I believe.
Or did we just continue
We're at
it?
the point where we decide, because of the reconsideration, we have gone back to just before that prior motion was made.
Okay, was there a motion on the
There
floor?
was a motion. Let me look in the packet.
Okay.
And through the chair, we had found violation when we had decided it was a passive meeting body. So there was a violation. So if we're going back before then,
Right, so we have to go back to the very last motion that was already in play. And then we take that and either amend it or do something else with it. Member Josh Wolf.
It seems to me that essentially what exists in the existing order of determination isn't inaccurate. It just needs the addition that we find a violation of them as a policy body.
Was there an OD for this?
OD was, we did determine that it was a passive meeting body and that a violation occurred.
Okay.
But we have rescinded that vote through reconsideration, and we are at the point just prior to that motion being made.
Actually, no, we didn't. No,
Not rescind, but
no, we take it back to the point of just before the vote. So the motion that's on the floor was that there was a violation, but that this was based on that the body was considered a passive meeting body.
So
Now, do we vote on that, or?
Hold on a second.
the member who made the motion is not present today. I don't know if that matters or not. This was
Doesn't matter.
all right.
Once the motion's on the table, it's ours. Member Hinsey.
So now do we vote on that
So
motion?
basically, if there's an amendment to the motion that currently is on the floor, because of the new information, if that compels you or us to change the motion, then we should do that first. You can either amend the motion or make a substitute motion, which would remove the original motion on the floor and replace it with the substitute.
So if not, we
But-
can vote on it.
And then we vote, and then after that, we'll take public comment, and then we will vote on it. Victor, did you find it?
Yes.
Okay.
The previous motion was moved by Vice Chair Hyland, seconded by Member Hensy. Moved to find that Tom Cagney and the Arts Commission violated Administrative Code Section 67.4A by failing to make a passive meeting accessible to individuals upon inquiry.
Okay.
So I would like to amend the motion and instead have it be a 67.5 and a 67.7 violation.
Would you like this to be a substitute motion?
I'm not sure I understand the difference
So-
between an amendment and a substitute.
If the motion that is currently on the floor is just point of order, standard Robert's rules. If you have a motion on the floor and your new motion is kind of all-encompassing, that would kind of usurp the motion on the floor because everything in it would be substantively different, then it would be a substitute motion. If you are making an amendment to add something to the existing motion and it's more like secondary, but the focus is still the same. So I think
No, we
this
should substitute. So this would be a substitute amendment, a substitute motion finding for violations of 67.5 and 67.7.
Can I ask a question?
Sure. Well, let's get a second on it, and then we can have discussion on it. Is there a second? to the
I'll
motion?
second.
Okay. Moved by Member Moss, second by Member Kanata. I'll reiterate, this is a substitute motion to replace what was the current motion on the floor. Member Fisher.
So, Member Moss, let me get my head around this. You're saying violation of 67.5, meaning meetings open in public, Brown Act, so you're implying, and I'm inferring, that this is a public meeting. But Ms. Patterson just got up and said, no, I'm sorry, Victor, what did she call it?
Policy.
A policy meeting. So you're going in with this is a public meeting?
So in either case, it's a public meeting. It's just a question of whether this is a passive meeting body or a policy body.
Well, it's not a public meeting because not anybody can walk in.
No, all right. So it's a public meeting in that this is a meeting
But
of a public body.
is it a public meeting, though?
So Ms. Patterson's argument is that this is a passive meeting body, which is a public meeting body. It just has a passive meeting body has different regulations under the Sunshine Ordinance. So we can go back through and look at exactly what a passive body is, but a lot of that comes down to like agenda and things like that. I don't think, if we want to go and look at that, let's see, I can look at sort of passive meeting.
Because maybe I'm coming at this wrong, but I didn't see this
So
as...
a passive meeting body is accessible to the public upon inquiry, as opposed to a policy body would have to go through the full Brown Act sunshine.
Did we get a yes or no from Ms. Patterson if this is a passive or a policy? Am I allowed to ask?
She just
Right here.
testified that this was a passive
That it's passive.
passive meeting body.
I want to, I want to
Yeah,
hear what she
sure.
has to say.
I'm sorry, I didn't say that.
my question.
I just said that this was not a policy body. I know that when we round one of this, we had submitted a letter identifying it as a passive meeting body. And then in a subsequent letter, let me just get my glasses, sorry. I sort of elaborated on how we viewed that and how we proceeded with regard to this meeting. Again, this was it was a working group of individuals who participated in the street artist licensing program. It was run by staff. There were no commissioners. And just bear with me while I find.
That's fine. I just wanted to get this clear because I'm pretty sure I knew that my head is interpreting what you were saying as what you were saying. I just want to make sure everybody else
Sure.
is.
So if I could just say that, sorry. So 67.41, such gatherings need not be formally noticed except on the city's website whenever possible, although the time, place, and nature of the gathering shall be disclosed upon inquiry by a member of the public, and any agenda actually prepared for the gathering shall be accessible to such inquirers as a public record. Now, I haven't seen proof where we've denied a requester that information.
Did I have a question?
Member Canada.
now?
I'm done. So
Member Canada.
So my question, you just stated this was a working group, but the question is, from the emails just presented, the full commission voted to approve the work plan, and this working group was created through that work plan, correct? The working group didn't exist before the approval of the work plan.
They voted on the proposed work plan, and so once the proposed work plan, and it's, if you look at, it's in the packet, it says at the top of the page, proposed work plan. But in any case, it was up to staff to then determine what staff capacity was with regard to the execution of that plan. So it wasn't necessarily that they voted to have the staff execute every point of that plan. It was a proposed plan, and then the staff took that back and determined what was actually actionable given our staff capacity.
Let me ask you a question. If you propose something to the commission and they pass it, is it still proposed?
Well, this was a proposed work plan, so there are multiple points. If you propose a public art sculpture, that's very concrete. That's different.
Right.
That's
but
different.
If
I don't know if you could compare.
But either way, if you propose something to an official decision-making body and they approve it, it's not proposed anymore. It's official.
Nevertheless, the plan was a general framework for staff to execute on certain initiatives at their discretion. And then everything that came out of that work plan was that was actionable, that required a motion to be ratified as a policy change, was presented at the full both the Street Artists Committee and then again at the full commission meeting, which concretized the policy.
It was my recollection that this body was specifically named in the plan. There wasn't like staff will determine if work groups should be created or focus groups or whatever, and it will be at their discretion to do so. The way I've read this is that it was that this particular working group was part and parcel of their decision.
It was part of the plan, but ultimately the decision was a staff decision to move forward with certain components of that plan.
Yeah, I'm not quite clear what the difference is. It's not clear to me from just a kind of a legal level.
Sure.
What the difference is. If someone proposed, if a staffer proposed that a working group be created, either by itself, just that proposal by itself, or whether it's contained as part of a larger plan, I don't see the difference, unless it specifically says that it doesn't state a particular kind of group. It just says staff has discretion to create whatever community engagement. And then if you create a group, then it becomes more of a passive meeting body at that point.
Well, I'm sorry, are you done? So thank you. So from our perspective, it's almost like the committee voted on a menu of items. And then the staff took the menu and decided which courses they wanted to eat.
Yeah, so that makes it, doesn't make it any.
Well, that's for
it
you
makes
to
it more
determine.
clear.
I'm not
It
trying
makes-
to argue with
I
you.
know. No, but
Yeah.
the point is we're trying to come to a.
Sure.
We're trying to come to a pinnacle here at some
Absolutely.
point. So
yeah.
I just just in my experience and having heard many cases somewhat similar with regards to passive meeting bodies, it's very clear with regards to a passive meeting body how it gets created. But when the full commission makes it a decision that it's where a group or a body, a meeting, a board, a task force, or whatever gets as part of the in words is stated and it's not stated as at the discretion of staff to create, to create a menu. They don't need to approve the menu. If you present them with the menu, then that's concrete. But if they give you discretion to create a menu and then you go off and create a menu as part of the everyday work, that's something different. They're not approving what you are creating.
Okay. Well, I'll just say that, from our perspective, this was just totally, after the proposed plan, after the commissioners basically said, yeah, this looks good, go explore this. Everything else was driven by staff. And from our perspective, when the rubber met the road, when concrete policy decisions were being made or put forward, that happened at a policy body level.
Okay. Member Moss.
So if you guys want to turn to page 211 in your packet. And then on the lower half of the page on item 3, where they're discussing this evaluation plan, it's described by the Deputy Director Correll. It says, she said that there have been 2 meetings so far focusing on this evaluation recommendations. At this meeting, so this is the meeting where they voted on, at this meeting she said the work plan is being introduced for approval to start implementing pieces of the recommendations made in the report. So for me, this indicates that this body believed it was voting on specific parts of the plan to implement. And then if you jump down to a couple more pages to page 214, and it's about midway through the page, and there's a section that starts in answer to Commissioner Sciotta's questions, and this is where they discuss what the actual community engagement group is. And it describes that they are key stakeholders, which would meet on an ad hoc basis with decision-making functions. So not only would they just be making advice, but they would have some sort of decision-making functions. They would work with staff. They would introduce concerns and help come up with creative solutions. And then they explained what the criteria would be for the participants of the group. And then they would then they explain a little bit more about it. So to me, this shows a process in which this body was presented with the idea of creating a working group. They were told by the Deputy Executive Director that they would be voting on this to approve, to make things happen. They were given a description of what this body would do and who would sit on it, and then they subsequently voted to approve it. And to me, that meets the criteria of a policy body in that it is a body, whether it's advisory or not, that is created by a policy body.
Yeah, I have to agree, because if it's stating that it has decision-making functions versus providing advice, that's it's a pretty those are kind of intentional words. Member Eldon.
I had been on the subcommittee that first heard this, and I think this is the third time reviewing the materials and learning a lot more, and it's become clear to me that it's a policy body, and the Arts Commission may not have intended that or doesn't believe that, but it just checked off too many boxes that, for a lot of different reasons, the laws are in place to have as policy bodies. So that's where I'm coming down, I think, and the process has really made that clear to me.
Okay. Anybody else? Should we move to public comment? Okay, public comment on the motion. You're party to the...
No, I'm not.
It's just William Clark.
Oh, I'm sorry.
My
Forgive me.
apologies.
That's okay. It happens all the time. Robert Clark. I'm in favor of the motion, but I really wish that the task force would listen to the end of the last meeting where this was discussed, because it's my recommendation. I'm remembering it as that the old motion was taken off the table, and this gentleman over here made a new motion that there was a violation, that it was a policy body, and that there was a violation of those sections. So I don't think you really have to be arguing whether or not this motion should be voted on, because I believe that the previous one was dumped already, and the new motion is the only motion on the table. And but I supported his position in that this is a policy body. I just want to say that this has taken us 10 months to decide whether this is a policy body, and I respect all of the people here, and that you're doing the best job you can. But I kind of resent the fact that we have a city attorney deputy city attorney sitting right here. Right after the first committee meeting, the whole concept was that we were going to ask the city attorney, who's an attorney, what the definition of a policy body is. And when the chair asked him that question, what did the deputy city attorney? He passed the buck. He said, well, I have these 5 or 6 other questions that you can ask, and then you all can decide for yourself. Now, what do we need a city attorney sitting here for if he's going to let you all decide legal questions? This is a very important legal question, and I resent the fact that all of us have had to come back here over and over again, 3 or 4 meetings, talking and fighting and trying to figure out what these words mean, a policy body and that. And I think this is a legitimate question that the city attorney should have made crystal clear. And I think part of the reason why they're not doing it is because they know my brother is right. This is a policy body. And the fact is, if it's a policy body, then we have new violations or serious violations. So I support the new motion, but I really would suggest you listen to the end of the last meeting, because the old motion was tabled and the new motion was presented and seconded, and then we continued the meeting to this meeting.
Is there any other public comment?
There are 2 issues that the Arts Commission hasn't presented clearly. First off, for a member of the public upon inquiry to ask, well, when is the next meeting? What's the agenda? When is it taking place? I did that, and I didn't get a response because it was an interrogatory. And the only thing I could do was ask for the documents after the meetings had taken place, which I did. So that aspect of it was not met by the Arts Commission. And then the second part is, I think you will see duplicative complaints. The working group is no longer in existence, but there is this advisory committee which has taken up some duties that were normally done by the Street Arts Committee, which I don't think meets anymore, or something vague as needed. I don't know what that means. But that also is a policy body. And the complaints that I have in the queue are very similar to this for that committee. And that's why it's important that this particular violation be decided in a way that the other ones that are coming up in the queue can follow, because they're almost identical.
Any other public comment?
I was listening to the deliberations, and one of you members just decided that, just hearing it superficially, no, we'll kill this. There's no substance to this. And two of you who were pretty astute laid down the policy issue, perhaps having in mind the Brown Act. But you know what I find very disgusting is how the Arts Commission thinks, oh, you know, we had this matter before and we decided about it and we killed it, and now, you know, if the gentleman brings it, we're just going to go with what we decided before. No. The Arts Commission is a rogue commission. And we citizens, not all of them are attorneys or very astute in these deliberations, going back and forth, back and forth, back and forth. But I hope now that the two astute commissioners on this board have laid it pretty clear, the city attorney wakes up. The city attorneys, both on this Sunshine Task Force and the Ethics Commission, and I'm going to speak about that when item number 5 comes, are not doing due diligence. And they have to do due diligence because they have to represent the citizens of San Francisco. And you know what? When the Sunshine Task Force was put together, why do you think we backed you up? Because we wanted you to represent us, to have your heart in the right place so that you could do due diligence. But when you bring rogue people over here, who do rogue things, who do things that are corrupt, then we find it difficult to get adjudication. So no commissioner should jump up and wave her hands like this, oh, you know, like as if you're conducting an orchestra. This is very serious matter. This is a matter of a gentleman stating that this is a policy matter. He can bring the Brown Act in, he can bring other acts in, he can bring other legal acts in, so that y'all can adjudicate. This is not a very difficult matter to adjudicate. Thank you very much.
Thank you. Is there any other public comment? Seeing none, members, any last words? We ready for a vote? Please call the roll.
Could you repeat the motion?
The motion is to find a violation of Sunshine Ordinance Section 67.5 and 67.7.
Thank you.
On that motion, Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Tesfa, excused. Member Fisher.
No.
Fisher, no. Member Hinsey.
Aye.
Hinsey, aye. Highland, excused. Member Eldon. Eldon, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, let's call the next item.
Next on the agenda, we will temporarily skip over public comment at this time as it's not yet 5 o'clock. Next on the agenda is item number 6, file number 17070. Complaint filed by Michael Adario against Kate Patterson and Arts Commission for allegedly violating Administrative Code Section 67.21 and 67.24 by failing to respond to public works requests in a complete manner.
Point of order, please, through the chair.
Mm-hmm.
We just finished the last one, but there wasn't any follow-up. What happens next? It passed, so what happens?
Violation has been found. I will write an order of determination.
I don't have any, are you suggesting it be sent to a committee?
No, I was just
or
wondering.
anything? Yeah, there's, I don't
It's
think
just a
there's.
violation and.
Yeah.
Okay.
yes. I don't think there's anything more to do
I don't
with
think the
it.
body's
Thank you.
meeting anymore.
Yeah. Okay.
This item was heard before the complaint committee on September 26. If you like, I can provide a summary of that meeting in a moment.
Monitors members. Let me just ask, Mr. Dario, is this an item that is already in our packet? Or are you bringing new information?
It might be some new information.
Because we have rules on bringing
Okay.
late-breaking information because the other party wouldn't have had an opportunity to read it, use it, or
Okay. All right.
argue against it, so. Okay. Victor?
Yes, I will just read the excerpt from the minutes from that meeting. Mr. Adario, upon questioning from the committee, stated that he would like information which showed who authorized Mr. Lazar in 1974 to undermine the enforcement of Proposition J. And then Ms. Patterson stated that the Arts Commission does not have any records regarding any relevant advice provided by the Office of the City Attorney to Mr. Lazar, and that it is her understanding that any advice provided by the Office of the City Attorney was in a verbal format. Ms. Patterson stated that if any records exist, it would be protected under attorney-client privilege.
Okay. Mr. Dario.
Putting this in context, or going back a little bit, I did present this the first time along. Bill Clark wrote Proposition J that would give the street artist the ability to sell anywhere in the city. It was it stated that a board of artists and craftsmen examiners were appointed by the mayor, and this was overseen by the Arts Commission. This proposition was endorsed by Barbara Gelato, Hungisco, Moscone, Willie Brown, Hallahan, Peter Keene, the Reverend Cecil Williams, Ruth Aswala, Lawrence Ferenghetti, Harvey Milk, just to name a few. It did pass. Once it passed, Howard Lazar refused to endorse it. He was quoted in the Berkeley Barb, said, we only make certificates under the old law. Article 26, was actually, I believe, Article 24, it's a misprint. Howard Lazar, who was in charge of screening, told Barb, we only screen the work of street artists who are going to sell at the Embarcadero Center, or Embarcadero Plaza, which is now Justin Herman Plaza, that is now Embarcadero Plaza again. We have nothing to do with Proposition J. This led to a catastrophe. It went from 150 artists within a matter of months to over 870 that were not screened. The police department was given licenses or certificates to anybody. It went up to over 2,000 by the end of the year. Howard Lazar claimed that he was told by the city attorney not to get involved. He also claimed that the director of cultural affairs, who was Martin Spinner, I believe his name was, also told him not to get involved in it. I asked for that information twice. First they said there was no documentation, and then they said they're taking attorney-client privilege, that I was not I shouldn't get it because it's attorney-client. And one of the weird things about this is we pay the Arts Commission for our licenses, and it's supposed to be cost neutral. So in a way, I believe that we are the client. So even with that, it would be, I think, a wrong type of avenue that they would keep, that they won't give us this information. It's not a real estate deal. It's not confidential. It's not a police matter. I think that this information has strong historical value. I am researching the street arts program now, and this is a turning point in the street arts program. What happened after that, there were so many non-artists in the program that the Supervisors Francois, put in another proposition to overturn the first proposition. So this back and forth went on for about 9 years, from like 71 to 79. The street artists were treated very badly by the Arts Commission, almost a form of discrimination. And some of that continues, and we pay them for this. There's also this by the city attorney. The city attorney wrote the first police code, and for Howard Lazar to say that that doesn't apply to Proposition J is just not true. Supervisor Barbara Gelato asked for another city attorney opinion on this. This came out in November 1976, and he said since Proposition J did not recite an overturning of the police code, it's still in effect, and the Arts Commission has the duty and the authority to screen artists before they're given certificates. So what they're saying, they're talking out of two sides of their mouth. I believe there has to be some kind of documentation that the Arts Commission was told, or they proposed that they weren't going to get involved in this. And this was, like I said, led to a catastrophe, that the program was, I think, purposely sabotaged. Proposition J was purposely sabotaged and undermined, so the supervisors could have more control over what spots that the street artists could sell in. Thank you.
Okay, thank you. Any persons or witnesses providing any facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent. 5 minutes.
Kate Patterson with the Arts Commission. The issue described by Mr. Dario happened literally before I was born, and the person who was with the program for over 40 years, Howard Lazar, retired in June. So he was essentially our institutional memory with regard to this issue. I don't think this is necessarily about what happened in 1974. It's about the request that was made today, and we simply do not have any public records in the form regarding this, in the form of an opinion or any information from the city attorney to share. I believe that, remember this happened before email, so I believe probably, and I'm speculating, that any advice that was given over the phone. So we simply don't have a record to turn over. If we did, attorney-client privilege would apply. So that's our position. I'm happy to answer any questions as best I can.
Thank you. Any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none. Members? Oh, Member Josh Wolf.
I'm a little confused around the invoking of the attorney-client privilege, because if you have no records in the first place, what's the advantage of saying, if we did have records, we wouldn't turn them over because of this? So as I read it, they have no documents. However, there's this secondary part about they would be protected, and I'm just sort of having a hard time parsing how to really understand the meaning of that.
DC Acola.
You don't really need to parse it. It only comes up if they had responsive records where they were invoking it.
True, I'm just kind of confused why bother to invoke a protection against records you don't have.
I don't know, it was unnecessary of them to do so. I think it's unnecessary for us to analyze it.
All right.
May I?
Yeah, member.
I think this comes under Occam's razor. Like, the simplest answer is probably the answer. I'm getting that they just don't have any records for this. Is anybody thinking anything differently? Irrespective of whether they're under privilege.
I have a question for Mr. Dario. The question before us, to make it, let's see if we can make it to the point, is do they have records that you're requesting?
That's correct.
Okay. And if they don't have the records, and they claim that they don't have any records that are responsive, Either they don't have them because of they're too old and was part of a retention policy that they're not required to keep them, or the records that they had found were not responsive to your request. And so you could ask them for those records to make that determination yourself, but the purpose of the ordinance is to try and get you the records of exactly what you're asking for. So
Correct.
I'm trying to find your original request to them, and it seems like our file ends on page 388 when your September 1st, 2016 request was made. But I think I can extrapolate from the September 7th one, which is on page 387. But it starts with question number 3. But they do state in September 2016, they're noting more or less the retention policy. They claim that. I don't know exactly what the retention policy is with regards to these kind of files. And the question is do you have any knowledge of whether they may have these documents?
I have no knowledge other than there was a record that the Arts Commission staff, I believe, made a verbal record and testimony that Howard Lazar was known to keep meticulous records. And if it was a phone call, he would take notes. This was a major break in tradition or policy. The Arts Commission was screening people. This proposition that was endorsed by many politicians was voted on, and he says, we have nothing to do with it.
Yeah, but that's not in our jurisdiction.
Well, but I would say that the paperwork, there has to be some notes or something. And they didn't claim they searched for it. They didn't claim that they searched through the records and found nothing. They said, oh, it might have been a phone call. There were no emails back there. They didn't say we made an extensive search. We didn't find anything. And then they come out with, even if we did, it was a client attorney privilege, which is BS.
Okay, so let's take the first part. They did a search, did not find any responsive records to your request.
I don't know if when they say that, I don't know if it was an extensive search.
How should we? What should we do then? Becomes our question when it comes to that point. If there's a records retention policy, or if a respondent claims there are no records, and you don't have any, there's nothing corroborating that they would exist. Like if these were his personal notes, or if it was work product, not public necessarily. If they were notes that he wrote on public documents, sure, but it's been found that work product is what leads up to a public document. Until it's ready for disclosure to the public, it's exempt. So,
well, if I can
just trying to hone in on a way to put a magnifying glass on this, if possible, because we don't have any investigatory power to do any of this.
I understand that.
So we can only go with what's been presented to us.
But what I can say in response is we're going back before personal computers.
Right.
This was, and we have notes that Howard Lazar made with Quentin Kopp to talk about the budget. He was very meticulous in these note-taking, and he would write down everything that happened in the phone call. We have those notes. Where
did you get those notes from?
I believe Bill Clark has a good bit of those. Bill and Bob.
Did you get them from him?
I'm sorry?
Did you get them from a third party, or did you get them from the city directly?
Bill Clark got them from the city, and I got them from him. And they're in Howard Lazar's handwriting.
Right. So the question is were they found on a park bench? How were they acquired? Were they acquired from the city or on the back of a napkin?
No, I believe they're not here right now, that they could testify to it, that they got them from going into the office, asking for the paperwork and looking through the paperwork, and that's what they did at the time, and copying them. But what I would like to answer your question is for them to state that they made a thorough search and did not find anything pertaining to this, and also to go away from this attorney-client privilege. I think maybe a ruling on that's a bogus thing.
We have that's not in our jurisdiction.
Okay.
The only thing we can do is state whether the information is public or not, and then they have to cite some part of the law that would exempt it from release.
Well, can you, is it in your jurisdiction that say that if the records are there, then they should be public?
Right. First, we have to determine if the records exist. So before there was the internet or a hard drive, they were stored in a place called Iron Mountain, which was a storage facility.
Right.
And part of the ordinance was written in such a way to allow enough time for somebody to go rummaging through boxes of paper to retrieve those records. But the city created a retention policy. And so, a lot of historical information, is not available anymore because a lot of that stuff got thrown away.
Can I ask for them to do the search, see paperwork that they did the search, see the trail that these records are not available, not going on Ms. Patterson's word, but paperwork?
Member Wolf.
So, sort of circling back, based on what I'm hearing from you and circling back on my original concern, it's important that, as I understand it, that they identify what documents exist, and then presuming those documents are protected by attorney-client privilege, they would not be able to be made available to the public. But what it seems may have happened is that they identified that the category of documents you've requested would be protected under attorney-client privilege, and that the actual search to see if those documents does exist may or may not have happened. So if I could ask the respondent to come up for a second. That is on page 371 is the response. My question is as follows. First off, has there been a search for any and all documents pertaining to the complainant's request?
Well, I'm sorry because I don't like to print out the whole packet over and over again, but it should be included in this packet, is an email that I sent to Mr. Dario on September 7th, 2016, in response to this request, for which we conducted a search around an issue that occurred in 2006. Obviously 10 years ago. So we did conduct a thorough search in response to this request through archives.
And so there are no documents whatsoever, or there are documents, including some documents that are protected under attorney-client privilege?
We did not find any documents responsive to that particular question. Had we yes, I mean, we would have withheld them in citing attorney-client privilege.
Right, but even then, he'd be able to know how many documents existed, even if he couldn't obtain them. But at this point, there's no documents identified.
Yeah, no documents.
All right, great, thank you.
Ms. Patterson, before you leave. So I'm just curious, why would you cite attorney-client privilege? Was there some litigation?
No, I think that, to be extrally cautious, that we provided enough rationale in our response. I mean, I think that our experience is that, we didn't want to be cited for having failed to include all the information that we should,
So I'm sorry.
Okay, let me just rephrase that. We're being overly cautious insofar as that we just wanted to make it crystal clear that if we had an attorney-client privilege opinion, if we had it or not, we would still not turn it over. I mean, it was just overly cautious. I can see that it was superfluous, but again, we don't have the record. And Howard is retired, and this happened in the 70s.
I understand that, but for you now to claim attorney-client privilege, it leaves me a little suspect.
Okay, well, I understand.
Because it sounds like you're trying not to reveal information. You're withholding information under a certain kind of technique. And the question, we have to then question for what reason are you invoking attorney-client privilege at that point? Because it's one thing to say we've done a search and we haven't found anything, and then next to say, well, if we found something, we wouldn't release it under protection of attorney-client privilege.
I kind of get that, but at the same time, it is our policy not to disclose information that is protected under attorney-client privilege.
How is it protected?
Because advice, we concluded the rationale, it was advice from the city attorney, so that is protected.
But what was that advice?
Had to do with Prop J and whatever happened in 1974.
But it was a public ballot initiative.
But no, what he's talking about is some issue that happened in 1974.
He's talking about records that Mr. Lazar has taken personal notes of some kind, or
about a particular issue that occurred.
And some of those notes have been obtained. He's claiming they've been obtained by another party from the Arts Commission. So he was trying to get some similar notes from a different time period on a different subject,
right?
In the same way, and so somebody was able to get
notes, right?
But somebody was able to get them before, so
but not on the same subject.
Fine. Then? Okay.
Okay, but we did a search. That was the point of the first question. We did do a search.
Okay.
Through the chair.
Yes.
So I get what you're asking here, and Ms. Patterson-Murphy is one of our, sadly, more experienced respondents. We've seen her, I'm over here, many, many times. But she's also, unless I'm wrong, not an attorney. Are you an attorney, Ms. Patterson? Okay, so she's not an attorney. So I think maybe this whole attorney-client privilege thing, as stated by Ms. Patterson-Murphy, is a bit of a red herring here. And if you were still up here, I would ask you that question, Ms. Patterson-Murphy. I think we might almost be focusing on the wrong thing. That's my comment.
Anybody else? All right, should we move to rebuttals? Okay. Ms. Patterson, you have 3 minutes for rebuttal.
So this happened over a year ago, and again, our institutional memory is no longer with the Arts Commission. We did a thorough search. We did not find the records in question. If Mr. Aderi would like to submit another request, we can look again. And again, if we do find records that have to do with conversations we've had with our city attorney, then I will consult with the city attorney on an appropriate response. But we do not have the records.
Hey, Mr. Daryev, 3 minutes for rebuttal.
Maybe I'm a doubting Thomas, but I really have a hard time with believing that they have no records on this. Supervisor John Barbargelato, in November 1st, asked for a city attorney opinion, and he received it from Thomas Dolan, who wrote, Thomas O'Connor, who was a city attorney, who wrote the police code, the Street Artist Police Code, Article 24. And it says the preliminary question, which seems to be raised by the Street Arts Guild, is whether or not the Board of Supervisors can confer jurisdiction upon the Arts Commission to make this determination of who is a street artist. Period to the enactment of Proposition J as in the measure, the Board of Supervisors enacted Article 24 of the San Francisco Police Code, which set up a procedure for the Arts Commission upon examination to issue a certificate to a person that the applicant named therein has passed an examination, is entitled to engage in the display and sale of specific art and craft items set forth in said certificate. Proposition J does not recite that this article was repealed. Therefore, it is still in existence as of this date. The Board of Supervisors may exercise at their discretion amend various sections of the Police Code to provide a determination as who is the street artist and require a procedure for that determination to be made. So this is very specific. I can't imagine there are no notes for Howard Lazar claiming that someone, the city attorney, told him not to get involved with Proposition J. That would have been in July. I can't imagine that he's claiming also the Director of Cultural Affairs told him not to get involved in Proposition J. After Moscone and Milk and Lawrence Ferlinghetti and all these people said Proposition J was a great deal for street artists, Howard Lazar says, we're not involved. So maybe I have to ask more specifically for them to do a search, to record the search, who did the search, where they do it, and make sure there's nothing there, because I cannot take their word on what they say. I mean, if you go in and you want information from the FBI, they tell you when and where they did the search, and no records were found. We're just taking their word on it right now. So that's a possibility. I have to go to the next step. Thank you.
Thank you. Members? Is there a motion? Any more information you need? Member Joshua?
I don't think I'm going to get any more information, but I remain frustrated by the idea that you would ever use any reason for not turning over documents that you don't possess. You don't need a reason to not turn over documents you don't possess. And although these protections that we have in the Sunshine Ordinance don't exist in terms of FOIA requests, I'm reminded of making requests for documents and told if we have documents, they'd be protected under, national security pretenses. And being unable to know whether or not those documents exist can alone be very important information to have. So I'm frustrated by the additional information that only compounds the confusion as opposed to providing a solid information that no documents exist. However, in light of the fact that we have testimony that the Arts Commission has done a complete search and there are no documents, I'm sort of left not seeing an actual violation other than a lot of frustration in the way that the response was worded.
Is there a motion?
I'll make a motion for no violation.
I'll second.
Moved by Member Josh Wolf, second by Member Kanata. Public comment.
Why don't you make a motion for a failure to send a knowledgeable representative? Jill Manton has been with the Arts Commission as long as Howard Lazar was, if not longer. She was his boss for many, many years. And she still works there in the same office and very close proximity. So I think the questions that need to be asked weren't. This is pure Kate Patterson. First off, what was the time frame that she did the search? Typically, it's 30 seconds. That's not even enough time for anyone to take a breath, much less do an extensive search. Jill Manton would have been the correct person to go to from the beginning. And if you look at the original request, on page 359, he is asking for city attorney opinions also. Once an opinion is finished, it becomes public. If you walk into the reception area of the city attorney's office, you're going to find books and books in the reception area on shelves. Those are city attorney opinions. You're not necessarily going to find them online, but this is public information. It would not be protected under attorney-client privilege. And I am sure that if someone did a search of some sort, not a generic, we consulted the city attorney. Well, who was the city attorney that they consulted? What was the date? What was the time? There should be records of these things. Also, it would be a simple matter just to go out to the reception area and pull the book that has the city attorney opinion on this particular matter. It's there. I'm sure it is. And anybody walking into that office who would just simply ask, can I look through your books? They probably would say yes. So this is pure Kate Patterson. We consulted the city attorney, and they told us. It's constant blame shifting with her when the problem is it's her. She doesn't know how to read it, she doesn't understand what's required, and she just quickly dismisses it by saying, we don't have it. Well, did she ever contact Howard Lazar? Was he asked to attend today? If he's the sole source of information and it's his memory that all this turns on, that's pretty lame, but did anybody ask him? How was this search done? Because in the many, many document requests that are made through multiple people, it's always the same thing. We did a search. It never identifies what documents they have, what documents they don't have, and which are in the redacted form.
Thank you. Is there any other public comment?
What prompts me to make my comments? Very simple. You have a person sitting over there who made a statement that Mrs. Patterson appears before this body, and apparently, according to her subjective opinion, she does her best, and she's not an attorney. Now, having said that, I was talking to William Clark about Native Americans, more Army personnel, and other veterans who did not have to pay a permit to own a stall. But the gentleman you all are discussing, Howard Lazar, defied whatever rules were made and would charge our veterans. And at the Board of Supervisors, I spoke. And then I came out. And he admitted, yes, there was a time that our veterans didn't have to pay, but now they have to pay. So who makes these rules and regulations? Howard Lazar. And who defends such type of rogue employees? The people who come over here that one of your commissioners says to all of y'all, oh, you know, she appears before us and she does this and that. Yes, does she? Now, it has been stated here that indirectly about William Clark, he should be brought here. Because in the case that I'm telling you, he initiated legal language and helped our veterans. Howard Lazar can be brought here. And we're not going to force him to hand over his documents, but let's bring him here and see if he has the moral fortitude to speak to the truth. So there's more than one way that we can arrive at getting some information. Don't rely on the Arts Commission and Ms. Patterson, because again and again over the years that I have come here, and I've come here many times, she'll come here and very arbitrarily make general statements. And some of our commissioners on this Sunshine Board do not have the guts to ask questions, think outside the box, so that we can corner her. We need to corner her. The time has come to corner her. Thank you very much.
Is there any other public comment? Seeing none, members? Any further discussion on the matter? Seeing none, please call a roll.
On the motion, Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Highland, excuse. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Tesfa, excuse. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Let's go back to number 5.
Next on the agenda, item 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
Please step up.
So, board members, I was listening to the ethics commissioners, paying very careful attention. And a number of members on the ethics commission called y'all names. One of the terminologies used was screwballs. The Sunshine has board members and call y'all screwballs. And I think this is very offensive. I know some of y'all for a long time. You know, board members that served here, Doc Comstock, Ann Williams, going back many years. And y'all do a good job. And this board has had some difficulties when the seats were not filled. More a seat that is linked to somebody who's physically challenged, I believe. And I was listening to the Ethics Commission, and they seem that they can go forward doing what they do best, negating whatever y'all forward to the Ethics Commission. And my advice to some of you here, more the astute ones who have your heart in the right place, is to represent the people. This is voluntary work. I don't know, y'all must be getting some breadcrumbs, but it's more voluntary work. If you really do your work, you have to read tons and tons of documentation. And we, San Franciscans, appreciate it. I do not know if this Sunshine Task Force is televised, but I do know that the Ethics Commission is televised. But I know for sure the Arts Commission is not televised. So what do they have to hide? So, as I said, I've been following y'all for a long time. I come to the Board of Supervisors. I prefer to go to those things which strengthen the subjects that I know: planning, infrastructure, land use, education. And I belong to a number of groups that support ethics, and I wish all the best. But still, there's a lot of cleanup to do. Thank you very much.
Any other public comment? Please step up.
Yes, when the New Year regulations come up, I would recommend, along with this gentleman, that you see if you can get these meetings televised. I think that would go a long way. Also, I would look into the possibility of requiring all city employees to learn about the Sunshine Ordinance. and possibly take a test on it. All city employees should know they're working for the citizens. Have a college course. If you're working for the city, if you're elected, if you're a legislative aide, you take a course, you pass the course, and at least I think this would maybe negate some of the problems we have over and over and over again, where, you know, if they knew that when they write a public document or they write something on a document, when they're getting paid by the city, most likely it is a public document. And it's open to everybody looking at it. So I think that some people don't know that work in the government. Some people don't care, and some people just will go against it. And you know, they'll come back with this the excuse that they didn't know. Well, if there was a course and a test, they couldn't come back with that excuse. So that would be my recommendation. Thank you.
Before we hear next speaker, Mr. Dario, it's not well known, but there is a city law requirement that every city employee must take a test and submit a form that they took the online. It's kind of part like a video with a little bit of a written test every year. And on top of that, there's some other ethics requirements regarding harassment and things like that. But you can find those on the city attorney's website. They're posted there. But there is a requirement. Whether it gets reviewed or anything like that's another story, but everybody has to submit a form that they have reviewed the video and the exam. Okay, public comment? Keep going.
Good afternoon, members. My name is Kevin Williams. I'm a resident of San Francisco and formerly Chief of Contract Compliance with the City and County of San Francisco Human Rights Commission. I worked for former Mayor Lee, our recently deceased Mayor Lee, for about 10 years. I will say I told better jokes, but that mayor, I got a lot of training. He was a lawyer, and I got a lot of training from the city attorney's office on how to pass depositions. And when I retired in 2005, I transitioned and found that that skill set was transferable to courts of law. And I've testified before judges and juries on the issue of discrimination, both in sexual harassment cases, racial, disability discrimination, equal partners benefits, and the entire gambit. The reason I'm here today is that one of the things that I know as an expert in the field of what I do, credibility is everything. So as you deliberate on issues of importance, you can assess the credibility of a staff person just as you can assess my credibility right now, and whether I'm telling you the truth, or do I have a history, or is there some valid and meritorious testimony that could persuade you that I don't deserve the credibility. Mr. Dario, Ms. Truax, Trabeau, Mr. Clark, the Clark twins, myself, we can't all be wrong. They are testifying about facts of which I've been intimately involved in. In fact, I sued the Arts Commission through the Bayview Hunters Point Arts Council on the issue of passivity and passive meetings as it pertains to employees who claimed that their actions had nothing to do with the commission. So I suggest that you look at the appellate finding in Bayview Hunters Point Arts Council versus the City and County of San Francisco Arts Commission. You'll find the truth. And then you'll be able to make a better assessment of whether or not Ms. Patterson has credibility. I would also go further to say, in that same context, when Ms. Patterson speaks, she's being told what to say. In my presentation, I will show you Exhibit A, that she does not act alone. She is taking direction from Mr. Tom DeCaney. Thank you.
Yeah, I just, in the future, if you have a case before us, you kind of treading the line a little bit is, in general public comment for items that are not on our agenda.
Okay,
So
very good.
just in the future.
Well, I thought I'd do the same thing the Arts Commission's been getting away with, but I digress.
In the beginning, I was frustrated coming to these meetings, getting slandered, getting personally attacked with a lot of made-up nonsense on the part of Kate Patterson. And I wondered, was it just her, since I don't know this person? She just foams off at the mouth, no evidence ever presented. Or is it other people of the Arts Commission? And in listening to other people's hearings, I am understanding that it is other people of the Arts Commission. I don't know Tom DeCaney. I went to the full commission meeting, the last one. The last time I was there was 2 years ago. I invited him specifically to come to the meeting today because there were multiple complainants. He snickered and jeered at me. It's always the same thing with them. They take no interest in it. Kay Patterson is just the name on the complaint. They don't care, and it's obvious. Even in the audio of the last full commission meeting, one of the commissioners had a hot mic, and you could hear what they were saying, which was quite shocking to me.
Any other public comment? Seeing no public comment is closed. Let's go to the next item, please.
Next on the agenda, item number 7, file number 17096, complaint filed by Kevin Williams against Kate Patterson and the Arts Commission for allegedly violating Administrative Code Section 67.25 by failing to respond to a media disclosure request in a timely and/or complete manner. This was heard by the Complaint Committee on September the 26th.
Point of order question?
Sure. Yeah, point of order takes precedence. Go ahead.
Yeah, I'm just checking my. So on September, where am I reading here? 26th? Yeah. The Complaint Committee determined that they have jurisdiction. I'm not sure who to ask. Is this jurisdiction because it comes under 12L because they get more than 250,000? I mean, they're a
I believe
nonprofit.
the request was originally sent to the the Opera House. However,
Which is a
they forwarded it to the
501(c).
Arts Commission as the proper respondent, is my understanding, and the Arts Commission responded to the request.
Again, my question is, why do we have jurisdiction if it's a 501c3?
Because they have a city contract.
So it is the 12L that comes under that?
Yeah,
I believe
that will be discussed.
I'll let Nick answer this if it's okay.
Yeah.
So apparently the original request was sent to the Opera House, but the Opera House forwarded that request to the Arts Commission, and the Arts Commission accepted it, saying that they had the records. So you've got jurisdiction because, well, the Arts Commission accepted a request on behalf of, or agreed to honor the request on behalf of the third party, and they accepted it as a regular 6721 or 6725.
Thank you.
Okay. Go ahead, Victor. Finish.
I believe that covers what I was going to state. It was submitted originally to the Opera House, forwarded to the Arts Commission, who then responded. They gathered information and did provide it. And I will leave it at that. There was a request for information. I believe the petitioner believes there's additional information that has not yet been provided.
Okay, thank you. Okay, both parties are here. Okay, you have 5 minutes.
Thank you very much.
Mr. Williams.
That is correct. At the last September 26th meeting, the committee members directed me to prepare, following that meeting, a list of public records requested originally on August 16th, 2017. But to date, as we are here today, those records have not been disclosed. For that purpose, I go back to the operative complaint item by item, and I'll summarize them. For the failure and refusal of the respondent to make full disclosure in response to several cognizable Sunshine Ordinance requests for public disclosure. In addition, there are misstatements of fact and evidence made by Ms. Patterson, for which time constraints didn't fully permit me to adequately rebut. But since that time, in an October 2nd rebuttal following that meeting, I addressed those issues. A more thorough review of the Respondent Art Commission's responses since the September 26 complaint hearing reveals there has all along been a concerted effort to willfully stonewall full disclosure and compliance with the Sunshine Ordinance by the Executive Director of the Arts Commission, Tom DeCaney. A recapitulation of email communications show that first on August 17th, 2017 at 7:48 a.m., DeCaney texts the Bayview Opera House Executive Director, Barbara Okel, not to comply with the Sunshine Ordinance requests because the organization is a nonprofit. Secondly, he next instructs Patterson to invoke an improper and patently illegal extension under an alternate pretext that the request is voluminous in nature. Thirdly, Mr. DeCaney asked Patterson how Okel should respond. In that email, I'll put on the screen a minute, but I need to look at it first. And it's to Kate Patterson. And it says, "Thank you. Hi, Barbara. This is Mr. DeCaney talking to the Opera House Executive Director. Thank you for forwarding to me. I don't believe that the nonprofit Bayview Opera House is subject to the Sunshine Ordinance. It is my understanding that the ordinance only pertains to public agencies, in which case the requests would need to be addressed to the San Francisco Arts Commission, Public Works, etc." He goes on to say, "I'm copying our public information officer, Kate Patterson Murphy, to clarify and advise on the next step." And he says to Kate, "How should Barbara respond to this request?" I imagine she would inform him that the request needs to be addressed and submitted to the appropriate city agencies. When received, we'll need to invoke a voluminous records extension, and it's a pretty extensive request. Thanks, Tom. At this point, I've simply requested records that are readily disclosable under the Sunshine Ordinance basic request. It's an immediate request because any contracts that are awarded are disclosable at the time of the award. This is $5.6 million. Ironically, the respondent's reply, allegedly that no documents responsive to the request is available, and that she seeks to give Okel direction from the Arts Commission staff, which emanates from the director himself, Tom DeCaney. Sunshine Ordinance Section 6334 defines willful conduct of an elected official, department head, or other managerial city employee failure to discharge any duties imposed on by the Sunshine Ordinance. This is the email.
Monitors, members.
Any failure.
Hold on. Can you center that?
Okay,
please. Thank you. Can you zoom out a little bit? There's a button to zoom out somewhere there.
No,
Other
way.
Yeah. There you go. Perfect. Great.
Too much? Okay.
No,
You'll help me with that.
Thank you.
So the Sunshine, any deviation in essence from that requirement shall be deemed official misconduct. And I go back to Ms. Patterson. She should not be standing alone, falling on the sword by herself. She is getting direction from Mr. DeCaney in not complying. And it would appear apparent that the conduct of Mr. DeCaney is in clear violation and inimical to policy. To wit, I will cite this and stop. Mr. DeCaney ordered his staff and the Bayview Opera House director not to produce the requested records on both unlawful and unethical grounds. He further ordered his own staff to concoct a voluminous records delay through requesting an undue extension under 6253 et sec. And what that means is it's limited only to documents that are totally undiscoverable. So I will stop right there and allow.
Time. We will be asking more questions. You'll have more time.
Absolutely.
Okay. Any persons or witnesses provide any facts or evidence on behalf of the complainant, petitioner? Seeing none. Ms. Patterson, respondent, 5 minutes.
Does my time include the overage afforded to Mr. Williams?
Yes, we will allow that.
Great, thank you. So on December 12th, I submitted a letter in response to, in part, the letter that was submitted to you on October 2nd by Mr. Williams. And most of this is a recap of the letter I initially sent, walking all of you through the steps I took to respond to this. I first want to point out that this is not an immediate disclosure request. I believe that there were a total of 26 items. Many of them were not readily accessible and required further investigation. I think it's important to let you know that the Opera House went through a massive renovation. During that time, the building was transferred over to another department agency to oversee the construction. And various departments, so in other words, various departments have certain records that the Arts Commission simply does not have. Initially, I just also want to correct DCA COLA that initially this was sent to the to the Bayview Opera House, and then it was forwarded to me, and then I reached out to Mr. Williams about it, and then confirmed with him separately whether or not this was for the Arts Commission, since it was a little bit confusing the way the initial letter was worded, and he confirmed that it was, and at that point, I acknowledged its receipt and sort of initiated the process to fulfill the request. I think that, truly, we took this request very seriously. I worked with staff to go through all of the records in our possession. Again, many of the records we did not have. And with regard to the nonprofit and the way that our internal conversations, which I've turned over to Mr. Williams, have been characterized, I feel like it's false. This was, again, initially received by a nonprofit, and we had some internal questions about what the process was. I've never seen a sunshine request given to one of our cultural centers, and I was unaware of what their requirements were with regard to being responsive to a sunshine request. So we had some internal communication between Barbara and the staff within the Arts Commission, as well as the city attorney, to gain clarity. It was not in any way intended to compel the cultural center to withhold information. It was very much an effort to understand what our agency was in terms of compelling that nonprofit to turn over specific documents. And I think that Admin Code Section 12L1, and which I included in my last letter, it gets very specific about what nonprofits who receive over $250,000 are required to turn over. And then in addition to what's stipulated in that section, everything else is voluntary. And the Arts Commission, they're an independent 501c3, and while they are obligated through their grant agreement to comply with this, but beyond that, we can't compel them to turn over other things. Specifically, Mr. Williams asked for information related to donors and their donations. In essence, there were a number of records that we simply did not have. We did not erroneously invoke an extension. I stand by the fact that this is not an immediate disclosure request. This is at the very least, a standard request for which we would have 10 days to respond. And then at the end of those 10 days, we would also have the option to invoke an extension. So it required a lot of staff time. At the last meeting, I was very saddened or upset to hear that Mr. Williams believed that we had purposely withheld information, and I took that to heart, and I went back and I asked staff to go over every line item again to double check that we had turned over all the documents that we had in our possession. And to my total frustration, it seemed that we had some information that we did not turn over in the first go-round, and I immediately turned that over to Mr. Williams. So aside from the fact that that section of information came later, I don't see any other violation. We took this request incredibly seriously. We did a thorough investigation. I went out of my way to inquire on Mr. Williams' behalf of the other city agencies to connect him with the appropriate staff people to fulfill the aspects of this request for which we did not have records. Thanks.
Okay, thank you. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent?
Good evening, Commissioners. My name is Barbara Mumby Huerta, and I am the Interim Director of the Community Investments Department. It's my team that worked with Kate to acquire the records. And I just want to confirm that we did take the request very seriously. We did our due diligence to search for the records and turn them over. We have nothing to gain by withholding records from any of our constituents, and our department itself prides itself in being very transparent in the work that we do. So I just want to confirm that we did our best effort to make sure that everything was available to Mr. Williams in his request. Thank you.
Thank you. Are there any other persons? Seeing none. Members? All right, I'll start the ball rolling. Ms. Patterson, I have a couple questions. So, first off, this is an IDR. It was page 402 of our packet. There is a letterhead dated from Mr. Williams, dated August 16, 2017. And it says right on the top, as required by the Sunshine Ordinance, Sunshine request for immediate disclosure of public records.
I don't dispute that. What I regret saying is that while it's labeled an IDR, it's absolutely not. It does not fall into the category of right.
What? Can you explain that?
Well, the items that he requested required, some of them it required redaction, some of them required, just.
So how does that not make it an IDR? IDR is a time factor. It's a time factor. It's not a.
Excuse me.
Anything other than that.
I think what she's trying to say is that although it was an IDR, based on the requirements to satisfy the request, she was within her right, and it was reasonable to invoke an extension.
Precisely.
Yeah, but you can't. But that doesn't convert it into something else. It's still an IDR.
Okay, that's fine. I did invoke an extension citing voluminous records and provided rationale.
If requesting an extension is provided for under the rules for an IDR, that's neither here nor there. I'm not disputing that part. Okay, but we've had other city officials that have rudimentary and without any explanation have told members of the public that their IDR are converted into a standard request under 6721, making all the requirements under 6725 moot in their eyes. We have ruled absolutely against that. There's no allowance or authority for a custodian to convert a 6725 into a 6721. If it's voluminous, a 6725 allows for documents to be provided on a rolling basis.
I didn't do that.
Basis. No, I understand. I'm just explaining what it is. I don't know what DCA Cole is going to say, if he's going to refute that or agree with me, but.
I just don't think it's worth going down that rabbit hole. What the task force should be focusing on now is whether or not the extension that she invoked was reasonable.
I don't know that we rule whether an extension is reasonable or not. Can you explain how that works?
I think you should look at what was sent that was labeled as an IDR. You should look at what do you think and what do you think went into satisfying that IDR, and then determine whether or not a 24-hour turnaround to get that out was reasonable. If you think that it may have involved more work than that, then you find that the invoking of the extension was reasonable, and then you move on from there.
I agree with you on that. That's just part and parcel of the IDR allowances, and it provides for a rolling incremental basis over time. I think we're not in disagreement.
I just think that that analyzation process should take place now.
I understand that, but I'm specifically saying that there is absolutely a difference between a 6721 request and a 6725 request, and you can't convert a 6725 request into a 6721.
Nobody's arguing with you on that.
Well, that's what it sounded like to me. That's exactly what part of the testimony was. Testimony is that we don't think this is an IDR. We think that this is a regular standard request. And we've heard that before from city staff.
Can I clarify?
And we have found them to be wrong about that. And they continue to do it. I see it all the time.
I just want to clarify that what I meant was that this was not, it was not an IDR insofar as that it was not, didn't follow into that criteria given the number of questions and requests.
Where does it say that in the ordinance?
There's a miscommunication here. What she's saying is she invoked an extension, making the 24-hour timeline moot.
That's not what she said. She's saying because there are 24 or 26 items.
She's not saying that it automatically makes that no longer an IDR. She's saying she invoked an extension.
I didn't hear that in her words.
She invoked an extension. Now just determine if the extension was reasonable.
Well, through the chair, she invoked 14 days, and 6725B allows a 10-day extension.
Right.
CPRA allows up to 14.
Can I?
But the ordinance overrules that to make for more expediency and transparency.
Chair Wolf, can just one comment?
Yeah.
Can we just find out if Mr. Williams got the records he was looking for?
We will get to that, but please, I don't want my comments to be abridged or my train of thought. Okay. Member Kanata and Member Joshua.
I'm just saying that the ordinance allows for a 10-day extension, and even if you exercise to the 10-day extension, you should inform the petitioner that because of the voluminous nature, you're going to provide data as you find it on a rolling basis.
Member Josh Wolf.
Yeah, a question for the respondent, if you could come back up, if you don't mind. I apologize for stand up, sit down. I understand that essentially they requested an IDR, you felt that it was voluminous, and so you notified him the next day of an extension. What I don't understand is why, rather than a 10-day extension, which is what is cited in 6725, you cited a 14-day extension. What was the reasoning for that?
Well, I guess my question is why, I have been advised by the city attorney that a 14-day, excuse me, if you can't maintain decorum during these hearings, I will walk. Okay, so please, if you can, keep the peanut gallery, respectful, I'd greatly appreciate it. It's very difficult to be up here doing what I'm doing right now, and I give the same respect to other people.
So I will ask that the members in the gallery to please keep their comments to themselves. If you have difficulties with that, please take a step outside. Please, if you have something that you have concerns about, you can step outside and deal with that, but not in here. Thank you.
I appreciate that. So I have been advised in the past by the city attorney that it's perfectly reasonable to invoke a 14-day extension as allowed by state law. So I invoked a 14-day extension.
So I think that is sort of the breakdown. If I don't know whether you have this part of the Sunshine Ordinance handy, or if there's a way for me to show you, but if under 6725, which is where the immediate disclosure requests are listed, letter B, which I think is what we're referencing here, if the voluminous nature of the information requested, and then its location in a remote storage facility or the need to consult with another interested department warrants an extension, I think that's what we're talking about, an extension of 10 days as provided in Government Code Section 6456.1. So my understanding is that if it hadn't been an IDR and you needed more time, then that may have fallen under a 14-day extension citing the California Public Records Act. However, because it was an IDR, the extension, as I understand it, should have been 10 days instead of 14.
Well, okay, that's for you to decide. I mean, perhaps DCA COLA can give an opinion on that.
Great, thank you.
Thanks.
6253C says that in unusual circumstances under the CPRA, you can invoke an additional extension of not more than 14 days. If the same circumstances that were listed in the extension under 10-day under the ordinance, if they apply in these instances as well. So, and the task force has held, and California state law in courts has held that these 14-day extensions were valid in circumstances that were unusual.
Personally, I'm not disputing the time factor. The question is I did not necessarily, and maybe I missed it, but I didn't hear in testimony that an extension was invoked, but that all I heard was that this was being converted, should not be 6725, should not be an IDR, that it should be something else because of the nature of how voluminous it could be. It's neither here nor there, but the key point is not to redefine what we've been adjudicating and ruling with for all the time that we've all been here and prior iterations of the Sunshine Task Force.
So page 395 appears to list the sort of timeline, including the extension.
Okay, that's fine. I have another question which doesn't pertain to this particular point. Ms. Patterson, did you accept? I have a little issue with this because I think it's a 12L because the original request was made directly to the city contractor. Okay. And I've had some discussion with DCA COLA about that. We're not in agreement. And the reason why we're not in agreement is because it was by his reading that the Arts Commission had accepted the request on behalf of the nonprofit contractor. Can you clarify that?
Yes, I'll clarify two things. Number one is that from my position in responding to this, I saw them as two separate requests. So I owned the entire request, but answered it through the lens of my agency and what records we had. And then, obviously communicated with the director of the Bayview Opera House to make sure that she was being compliant with what were her responsibilities as outlined by the city attorney as we were trying to answer these questions about responsibility and what her requirements were. So I just took responsibility for the Arts Commission's records, which I know regardless we would turn over. I also just want to clarify for just being inarticulate that what I meant about not treating this as an IDR was just simply to illustrate that this was a very lengthy request. That's all. Okay? Thanks.
Yeah, please stay, Evan. Just want to have a further discussion with you on this. And what I was supporting you on was that you can still be an IDR and provide all the documents on a rolling and incremental basis.
Right, I understand, yeah.
Which, because of the nature, because of it's voluminous.
Yeah.
Okay. So the other question I have is did the Bayview Opera House have any of these documents that Mr. Williams was requesting?
Yes, they did.
And did they provide that to him?
They did provide them, and
were there documents they didn't have that you had?
No. Well, I don't know what the overlap. I didn't analyze if there was overlap, but
did you provide any documents to Mr. Williams?
Oh, we provided a ton of documents,
Okay.
and I enumerated them in our response letter. I created a whole Dropbox with all of our records organized by the actual request number. So I didn't, there were so many, I didn't sit and analyze who had who necessarily. I just took care of what we had.
Mm-hmm.
And I know that Ms. Ockel provided the city monitoring letters, current budget, tax returns, financial audit. According to Section 12L1, she also owed them some minutes from her board, and per the discussion we had.
Mm-hmm.
I don't know if she's sent those. I've inquired. I inquired as early today, and I don't know if I heard back. I'll have to check my inbox. So we did provide whatever we had for each item. You know, we had some board minutes. We just turned over everything we had in response.
Okay, thank you. Mr. Williams, so did you receive all the documents that you requested?
No.
And which documents are missing or that you didn't get?
Following the September 26th hearing,
Mm-hmm.
I was directed by you to prepare a breakdown of all of the categories of documents that have not been received. I did such.
Mm-hmm.
They have not responded to any of that. In fact, the minutes state that they would have 5 days before this meeting to submit anything else. They have failed to do so. And
So what is missing?
So what is missing are the list. I'll just go back to the list.
Is it in our
Do we have a copy?
It's in the October 2nd response that you asked me.
the categories?
The categories, I listed all 26.
Okay. Hold on 1 minute. Is that in our packet?
I didn't see it online in the packet updated.
The original 26 are on page 405.
No, I got those, but that was part of his original request. I think the complaint committee had requested that they be collated by category to make it a little bit easier to. Is that correct?
That's absolutely correct. And I pointed out in each category what still is outstanding. They have not, since the notice for this meeting, the agenda for the meeting went out, they didn't submit one additional document. Let me just be very clear and concise. I'll just take it down to the minutes. I asked for minutes of board meetings between the year 2013 and 2017. They gave me 5 minutes, 5 for 5 meetings. That certainly does not comprise nearly 5 years of minutes. And secondarily, since they have a contract.
Before you move on, why do you think so?
I could.
Nonprofits aren't required to meet more than maybe once or twice a year.
But within that period of time, we're speaking of several years, they would have more than 5 sets of minutes.
Well, the question is if you know that that they had meetings and minutes were not produced, that's one thing. But if you don't have knowledge that they had any meetings, but there's kind of a supposition or a thought that maybe they should have them.
Well, Commissioner Wolf, you emphatically stated it on the record when the same question came up. I don't want to go back over the same thing, but I can categorically tell you from growing up in that community and having that theater being named after my own mother, mm-hmm. Ruth Williams Memorial Theater, they should voluntarily want to give me more than a ton worth of information over a building that is worth probably in excess of $50 million.
But we can only adjudicate based upon what the law allows for the release of records. We can't, suppose that that everybody's deserving of public records because they're property of the public. Okay, the question is how they're retained, how they're received, how they're distributed in that kind of way.
Yeah, I understand.
Whether anybody's more deserving or not, that's not really part and parcel to how we make our decisions.
Certainly.
So
I would agree. Okay. And I would go further to say that something such as the compensation, the composition of the board. I've asked for the resumes or the bio vitaes. I've not received that. I've asked for the salaries of the staff. I've not received that. I've asked for the specific amounts charged for particular businesses and organizations. Now, I understand for individuals, I can't get their addresses. I just want I'm entitled to the names, but I'm also entitled to the zip code so that we can determine whether those individuals are being charged in Bayview, Hunters Point, in that zip code, as opposed to people outside of Bayview, Hunters Point. That is one of the issues.
So these would be people who would be using renting out the facility.
Yes, for cultural events. And we are alleging that since the Arts Commission only charges the operator there at the Opera House $1 a year for the rental of it, and charges individuals in that zip code up to $4,000 for one event, we think it's probative that we know who the individuals are and where they are from by zip code. So that is disclosable. The other aspect of it is the where they're located, where they have a physical office, which is they've moved from the Opera House itself to 4702 3rd Street across the street. They refuse to tell us who the landlord is. Although I'm informed that one of their own board members negotiated the lease for $1,000 a month next door to a liquor store at 4702 3rd Street. So we asked for the lease agreement for that location and what they are paying for the rent and who the landlord is. We have a right to know that. I have brought people from the community who are active in that community that are asking me the question simply because my name is ascribed with that building. My name happens to be Williams, and my mother was a great woman who did theater there that saved the building from demolition in the 60s. So they come to me and they ask me to ask you because the people out there have a right to know. This is public disclosure, and they're being in the dark, and they believe that this is because there are nefarious activities. I ask categorically for proof of how they spent a published $5.6 million renovating that under its historical significance as a historic landmark. They have shown expenditures for just $2.5 million. To date, I don't know, nor does any member of the community know, where the $3.1 million went. So that is the public's right to know. Just because you're in a poor neighborhood does not mean that you don't have a right to know. This is the cultural hub of the southeast sector of San Francisco that I have the distinction of having a great woman. I would say she was great anyway. But they have a right to know. And I'm trying to bring the issues to the forefront of this investigation. You don't have an investigative role, but you have an enforcement role. Very much the same as any other agency that has that role and responsibility.
Actually, we don't.
I mean, a role not as an investigator.
We don't know. We don't have enforcement authority.
But you have the right to refer this to the Attorney General. You have the right to refer it to the district attorney. We don't really care about referring this inside to the district attorney. We think that at some point in time, this kind of acrimony and adversarial discourse has to stop.
Okay, so I think what we need to focus on here is, was there a violation? And if you have any outstanding documents that you didn't receive, whether the Arts Commission has them in custody or not.
Yes, they have them.
Because that's ultimately where our, or kind of how we make our ruling goes
I
to.
understand.
Okay? So I want to, continue to try to focus on.
Okay, I will do that.
On those items, because otherwise we'll be here for very long.
Sure, I understand.
Okay? And then we can go from there. So, so what I have from what you said, you requested minutes from 2013 to 2017. You received only 5 sets. So you wanted to know if there are more. You requested salaries. Okay, I did not receive that. That may be. It could be protected information. I don't know. There may be some personnel issues. I don't know. Entities, you want to know which entities rent the facility. I don't know between what time periods, but for the purposes of knowing which ones are San Francisco based versus which ones are not. You want, I didn't quite, you went through it pretty quickly, but you want some lease agreement for a particular location. Is that on?
They have a satellite office across the street from the actual theater.
And who owns that property, though?
Well,
okay,
it's someone
so you're
else.
Looking for that. Okay, got it. So you want that information from the nonprofit, I guess.
Yes, in as much as the Arts Commission tells them what to do.
I know, but if it's not city property and it's not a part and parcel to the city contract, then it's specific to the nonprofit. And if it's a private piece of property to them, it has nothing to do with the city contract, then it's really not disclosable.
Yeah, it does have to do. They're conducting business out of there by utilizing the grant funding to
okay, well, that's something
artists.
Different. That's
Yes.
something we don't know that.
Yes.
So you're looking for information regarding or reflecting that. Okay. And you're requesting the expenditures of the entire grant for the purposes of renovating and the management and the maintenance of the location.
Yes, the remaining 3.1 million.
Is there anything else?
Yes. I asked for all of their contacts in terms of who they conduct outreach to, specific to the people, the businesses and individuals that they conduct business with. What they've done is given me just names. They omit the email addresses.
So you're talking about outreach by who?
By the Opera House in conjunction with the Arts Commission.
Who's doing the actual outreach?
The actual outreach is in coordination with both are doing it. They get resources from the Arts Commission. They do not disclose to the community. And what we're arguing is that culture is in the hands of the city, not in the people who are intended beneficiaries of the cultural programs that they purport to be expending money in the Bayview Hunters Point community.
Okay. What else?
We have not received.
These are all listed?
They're all listed,
Okay,
Commissioner. I think that you can go down the list
and
you'll see.
That's fine.
That just gives you a thumbnail of what has not been produced or provided or released or disclosed to date.
Okay, let me ask Ms. Patterson now about these items that are outstanding.
I'm going to have my colleague Barbara Ockel.
That's fine.
Sorry, Barbara Mumby. Sorry, I apologize. Okay. I think the issue is, again, I think we need to. I think the issue is that a lot of these records the Arts Commission doesn't have. They are records of the Bayview Opera House. And so why don't you go down each line item and I'll tell you what we gave them, what we have.
So of what he iterated that he did not receive was he requested minutes from 2013 to 2017. He only received 5 sets.
Again, we gave him the minutes that we happen to have on records, but we don't have their minutes.
Okay, that's fine. And that's under 12L, that's required.
Yes, and I said before, I followed up with her on his behalf to just remind her to turn those over. I don't know what the universe is. I don't know how many minutes she has.
Fine. Okay, that's very responsive. Okay, so he was looking for the salaries of the people that work there.
So Barbara, go ahead.
So we wouldn't actually be able to give a breakdown of salaries. What we have provided is the organizational budget, which has a a total line item for salary and personnel in there, but it wouldn't be broken down by individual.
Right, okay. The entities that actually rent the facility,
So we do not require a list of who they rent. They do report to us how much income they receive off of revenue, and we do require them to provide us with a breakdown of their fee schedule and require that they do a sliding scale depending on who it is in the community, if it's an individual, a for-profit, or a nonprofit entity. So that's what we have.
so do you have that information? Have you provided that to them?
Yeah. Would it be in the budget?
It should be.
All right, well, we can get.
We can verify, but it should be in there.
I can look through what I originally sent, but yes,
Okay.
if we had it, it was turned over.
Okay. A lease agreement for this separate location?
We would not require them to submit a third-party contract with an entity.
Is that not city property?
No, it's not.
Was the city funds or grants that was provided to them used for that location?
I would have to go back to their budget during the period of time that they're in there to verify.
Do you allow entities to do that?
During that period, they were under construction, so they had the satellite office set up. So I would have to go back during
Okay.
that period of time to verify.
All right. Request of expenditures.
Expenditures for?
Of the grant money.
So whatever financial documents they provide to us each at the end of the year, it is an overall budget, a P&L. They're also a participant in the annual city's contract compliance and monitoring. So through that, they're also required to provide those documents to the auditing team. So those are things.
Auditing team in your office or some
It's
other
a
office?
cross-agency team. It's not just our office.
Okay.
And it's held by the controller's office.
Okay.
I think that some of the expenditures he requested went beyond what we would, they were more sort of granular about other events and whatnot that they hold there.
Okay. And then contacts for outreach.
So I have to look back, but I do remember that he did request contacts, information for outreach, and I kind of went through things that we had sent out in the past related to Bayview Opera House events that were issued by the Arts Commission, not necessarily in conjunction with the Bayview Opera House, and I provided him, we don't have zip codes for these contacts. They came out of Constant Contact, which is our email marketing tool, and I provided him with names, and we do not share personal email addresses.
Okay.
And I provided the appropriate rationale for withholding the.
All right. Is there anything else you'd like to add on what you provided?
I outlined everything we provided in my initial response letter. We can go through that. In addition, in the most recent letter, included the records that we missed the first round, which I provided. So I'd prefer if you have additional questions of records that he says that are missing, that are not there. Mr. Williams keeps citing the fact that we provided him with accounting for a portion of the total construction budget for the Bayview Opera House. Again, the Arts Commission literally turned that building over to other department, to DPW, for example. They have all the records.
So did you assist him in trying to find that information?
I did
from the other
initially.
departments?
I emailed the custodians of records at both the MTA and DPW on his behalf, saying this came in, just so you know. I then introduced Mr. Williams separately in an email. It's all in the packet to the custodians of records, and they required that he contact them directly so they could start their own timeline with regard to the records request. I forwarded the records that came to me from DPW. I immediately forwarded them to Mr. Williams and included them in the packet of information I created a Dropbox folder with. I never received SFMTA files, so I don't know. He was working with them directly. I don't know what he received. I never got them. Had I would have done the same thing.
Okay. Okay, thank you. That's all I have. All right, Mr. Williams.
Just as I sat down, Member Wolf, I remembered some other things that are a part of the October 2nd rebuttal. And
Well,
specific?
let me just say I'm not going to go through the entire list. I mean, it is quite extensive.
It is extensive.
I follow what the purpose is for, and I understand that there's some responsibility for. I wouldn't say responsibility. There's some information that is wholly contained with the nonprofit that is probably not required to be shared with the city or with anyone else for that matter. There's lots of laws around nonprofits and what they must disclose and what they're not required to disclose. And the Sunshine Ordinance for nonprofits under Administrative Code 12L has its very specific packet of information that's prescribed, and then anything else is voluntary. You can ask for it, they can voluntarily give it to you or deny it. And there's no requirement by the city to compel them to do that. But under those rules, you can, instead of coming to us, you go to the supervising body that oversees that contract. If you don't like the response you get from them, then you come to us, but it's only an advisory opinion. There's no, force of a ruling the way there would be in the 6721 or the 6725 part. So we can only, if we decide that we're going to run with the 6725 part, then it's going to be on the information that the Arts Commission is providing and not on what the nonprofit provides. Follow me?
I follow you.
Two separate procedures there.
I follow you. Okay. And what I would respond to is that the Arts Commission has submitted to the jurisdiction of the task force, so it's sort of moot in that regard. However, the categories of documents that I have requested involving bid documents, bid award documents, they didn't have to get an extension for even 10 days for that. It's disclosable at the time. She cites Government Code 6553 as the basis for requesting an extension. I think it was 6253 C2 and C3 as grounds to invoke an extension. That's on complaint page number 184. If you take a look at that, the only way that you can get an extension is if all of the records have confidential information and or not disclosable, all of the records. And the requirement of subdivision A of 6253, it says that the action of the public agency that determines a request should be denied and bases that determination solely on an exemption listed in 6254. The public agency makes available an index of records. No such exemption for a local public agency applicable to the operative Sunshine Ordinance request exists, where in section 6254, in some, what they did is invoked an extension that's non-existent because none of the requests that I made initially is for disclosure of confidential information. And they had a duty, as you've so indicated, to submit records on a rolling basis. The contract information was already available. They waited until one particular time, even though it was disclosable much earlier. The immediacy of the request was stated in bold letters in compliance with the Sunshine Ordinance. They cited a provision based on what she was told by her boss, Tom DeCaney. Because the request is voluminous, get an extension. Doesn't matter how voluminous the request is. If there are documents that are readily disclosable, they have to be disclosed at the appropriate time. Not 10 days, not even 14 days. So the point that I'm making, Commissioner, is that the records for accountability of how expenditures on the building were made is disclosable. The request for how they solicited bids was disclosable. The fact that they have not disclosed to date $3.1 million of an expenditure, they are still in non-compliance with that ordinance, because that is within their purview.
On that part, though, they're saying that this, at a certain point, the construction or the money that was used was being shared with, and the responsibilities of oversight were shared with other departments.
That's a misnomer. It's a red herring to confuse the issue.
It's not.
I told them that
it's the way the city operates. We've been through this with a number of other departments where there's a responsibility to provide certain information to the Department of Real Estate. Okay, that a department, where they're renting out to a nonprofit, that kind of thing. There's all kinds of interagency responsibilities based upon what's happening and how the money's being used. I don't know the particulars of this particular project, so I can't say. That's why I asked them specifically, did they assist you in finding documents that they don't have but that they know other agencies have, and that's a requirement of the ordinance.
Well, I haven't received a response to from any city agency where $3.1 million went.
But the point here, for the purposes of and the focus on the Arts Commission, the question is, did they do diligence to at least assist you to find the documents that might be held by other bodies, other agencies or departments?
I think the answer is implicit in the fact that they have not produced records.
They don't have to produce the records. All they have to do is assist you if they don't have them.
Yes, the city, categorically, the Arts Commission told me in writing that they would secure the records, not just assist me in finding them. And I told them that I would not make a request to several different agencies, because there is another definition that is all-encompassing that says I should not have to go to 5 different agencies where that work was performed on one project. Because the definition is narrow.
I know, but that's not necessarily for us to determine in that way. The ordinance is very specific that if a custodian does not have the and we're talking about people, not departments. Okay, the ordinance doesn't talk about departments. It talks about people who are custodians. If the custodian doesn't have a record, they're supposed to assist you into trying to find that. So it could be the person in the cubicle next to them, or it could be a completely different department. And so that's the question. To me, from what I hear in the testimony, that there was some due diligence, and I've read that there was some possibility that a lot of these records were contained and being managed or maintained by other departments.
Yeah, Commissioner, you've heard with evidence that the Arts Commission staff was told not to turn over even records that are clearly, that one would admit right now from the testimony you've received, are admissible, are public, and should be submitted. I even asked for at number 9, I believe it was, number 11 of my request in the rebuttal, consultant contracts, professional, personal, legal, office equipment, furniture, maintenance, accounting contracts, or vendor agreements between 2013 and 2017. And the payments to date did not receive those.
Okay.
And I think that because they received, even their own attorney has stated that these records are disclosable because they are recipient of a grant and they're leasehold. Their own attorney.
I'm not disputing that. I'm just trying to find out what documents you got, what documents you didn't, what documents do they have, what's outstanding, that kind of thing.
Yes.
And the question is where the violation is.
Yeah, Member Wolf, you asked me to submit what they didn't provide.
Right.
I did that for every category, 26 categories. Mm-hmm. They produced nothing. I think your own city attorney would tell you it's deemed admitted when they didn't produce anything contrary to that. So it's not appropriate for them to be allowed to come back now and say what they didn't do. They simply have not responded to the things that I last said October 2nd. They had an opportunity to respond before now to documents that they categorically said that they submitted. They did not. There's a violation based upon the totality of the evidence and not just one aspect of it. And Commissioner Wolf, I would also categorically state, I've worked for this city for 25 years in compliance. I know a little bit about the Sunshine Ordinance, and I also know something about the unsunshine ordinance, where the secrets and the skeletons are held, where the good people of this city have a right to know and a right to be informed about a nonprofit that has my name on it.
Through the chair, you know, I feel like we're getting into a bit of a monologue that's more like something that would be appropriate for rebuttals as opposed to, you know, the Q&A between, you know, the task force members in here. I just want to get to one point that I think you guys should really focus on. So if you could go to page 402 in the packet, where it's got the list of the 26 items that you put in your IDR requests. Can I just go through them and you say yes or no, whether or not you got it or whether or not you got it?
No, I won't do that, because I have put in writing in accordance with the chair asked me to do, and the ordinance, I would remind the task force also states, may I finish?
You could do that during your rebuttal.
I have the floor. The city attorney is not supposed to be, the city attorney's office is not supposed to be an advocate for another employee. You represent the good people of the city and county of San Francisco, and I happen to be one of those good people.
Sir, we're trying to I'm trying to ascertain, and that's exactly what he was trying to do, was go through the list to find out what you didn't get, okay? That's all that we were getting to, because we want to try to bring this to some close at some point and figure out where the violation is, what you're missing, so that we can tell them to provide it, and we will ask them through our Compliance and Amendments Committee to report that, and for any items that they have done a search for it, they cannot find, if they know that some other department has it, they'll report it as such. Okay? That's as best as as much authority is given to us by the Sunshine Ordinance and the way it's written. Okay?
All right. You got number one?
Yes.
You got two?
Yes. No. I thought you were talking about, I'm looking at it. I'm saying, based on what I have here.
Do you have something different than what's on?
I believe that the complainant keeps referencing an email where he listed what he didn't get, but I don't see it in the package.
Okay.
Yeah, it wasn't included in the package that I put together October 2nd that would obviate the need for going through each of these individually.
Okay. So
I can produce that.
Did you send it to us?
Yes, I did.
Victor, did we get this?
Everything I received has been included in the packet.
I can send it, I can resend it, but I have a copy of it right here.
Can you put it up on the screen?
All right.
Please. Thank you. Mr. Eldon, vocalize that. Yeah. Just tell.
I don't know how to do that. If you could help me with that, I don't know how to use it.
She's going to bark at me.
Yes, the rebuttal. No, that's not. Yeah, I have not seen this in the package unless I missed it. But
I certainly submitted it.
It's clear. Yes.
Okay. Thank you.
Okay, so number one, did you get that? That's the contracts.
With the exception of what's read.
Okay. The rebuttal part is the ones that you didn't get. Okay, gotcha. Okay.
I'll read it to the committee if it's allowable.
Okay, and I think at this point, if you'd step aside, we can have Ms. Patterson come and then confirm whether she has delivered those or not, and then we can.
Item 1.
On this.
Respondent produced only $2.5 million representing the prime contractors, MH Construction, within 9 change orders of approximately $800,000. Thus, $3.1 million does not appear to be accounted for no explanation. As for no explanation to accompany the response.
Okay. Well, what he originally asked for was provide full disclosure of any conformed copies of any and all contracts, grants, loans, bids, and any purchase orders, whatever kind that are directly related to or indirectly pertain to the $5.6 million historic renovation of the Bayview Opera House, Ruth Williams Memorial Theater. Please also include where and what trade publications and our contracts was advertised. What we provided him was a whole list, which you guys have. October 24, 2011, San Francisco Redevelopment Agent Grant Agreement. October 4th, 2011, Personal Services Contract for Cultural Capital and Historic Preservation Consulting and Advising Services, Mayor's Office on Disability. Here's the remainder of the list. I don't know if you want to, sorry, of all the records that we had in response to this request.
All right, I'm a little reluctant to go through an entire list like this because at some point, I'm saying maybe you should sit down with Naomi Kelly, the city administrator, and go through this because this is dealing with city contracts. That's her bailiwick, and I'm sure you know who she is, Mr. Williams. That may be a little more pertinent. I think we're happy to maybe have the Compliance and Amendments Committee spend some time to go through this, but that will take that scheduled at a certain time next month. Out of expediency, in order to get this is because it is voluminous. I get it, and I understand. I'm just trying to find a way forward here. Okay. So you get your needs met, and they can get some closure on this.
But through the chair, for the items that he didn't get for the missing dollars, if they are truly administered by other departments,
right?
Can the Arts Commission assist with these other departments?
That's what I asked that before, and I think the answer was they have already done that, but we can reconfirm it again if you want to ask the question.
We absolutely did do that. There's evidence that I reached out on behalf of Mr. Williams to inquire about these records, and then there's further evidence that I turned over the records when they were forwarded to me.
So the other question I have then, because I remember reading the package, and it seemed like MTA agreed to turn over the records through you or on
no,
their
not
own?
through me.
On their own?
No.
If a request was made or you asking was the request?
A request came in. I informed my colleagues.
No, you requested MTA and DPW to help Mr. Williams.
I informed them that this was a request, and then I made an introduction and so that Mr. Williams could request the records from those individual departments. They need to register their own individual requests so that they may decide what timeline is appropriate for them to fulfill that request. I cannot be, they're not my records. I have no idea what the universe is, et cetera.
I'm just trying to understand.
I did what was required of me to do.
I'm trying to understand if the department you talked to considered your request an official request for records or needed an official request from the complainant.
They asked for an official request from the complainant, but he refused. Okay. Nevertheless, they proceeded.
Thank you.
I'd like to clarify that.
Okay.
Because I didn't refuse to do anything that was inconsistent with the ordinance. What I did is simply said that it would be cumbersome on any citizen that had to go 5 places to get information where the project occurred on for one project. It was advertised as one project, not 5 or 3.
I understand it, but that's the way it works. Come on.
So I got it. I understand that. But in essence, I relied upon the representation made by the Arts Commission that they would do it. They took on that task. After I did tell them I wouldn't be jumping around a bunch of departments, they agreed in writing. We will get the documents, and they set a deadline.
Okay, so I hear you. That's very definitive.
That's absolutely not true. I'd love to see the writing where I agreed on behalf of those other departments that I would get their documents, because I absolutely did not do that.
Guys,
Do task force members have any questions, or should you let them go to rebuttal?
Please, I'm running this meeting. Please. I know you're irritated and frustrated, but we're running the meeting, not you. Go ahead.
I don't know who this is a question to exactly, but I'm just trying to understand is when we have a nonprofit that's doing business with the city and falls under this requirements, is there one department that is their like primary point of contact with the city, and is that the Arts Commission in this case? Anyone of my colleagues want to answer that so I can understand this better? Nobody. Can the Arts Commission answer that?
Well, so the question is, are we like de facto their single point of contact?
Yeah, is there a department that is the primary point of contact between the Bayview Opera House, the nonprofit, and the city of San Francisco, or does the nonprofit engage with various different departments of the city?
Well, I'd have to defer to Barbara, but I would say for the I'll defer to.
Yes, they do. We are the grantee or the holder of the grant, but they also report to the Department of Real Estate when it comes to certain issues with the building. And in the instance of the construction, there were numerous departments that they directly corresponded to rather than through us directly.
But you are the grantee, so you do at some level take on the primary city agency.
We oversee the grant, one grant that we provide to them each year, but they also receive funding from other sources as well.
Okay, thank you.
Again, members.
I don't actually have any questions for you, sir.
Go ahead. You have a question?
I said I do not. We don't need.
I just wanted to clarify that the majority of the funding for the Opera House, $500,000 a year. And most recently, in 2016, $700,000 a year. Those are major funding sources.
I understand that, but that's not within our jurisdiction.
Yeah, but it's misleading to indicate that they receive, they go other places for funding. They are the controlling agents with regard to the functioning of that Opera House. It is a city-owned building leased by the Arts Commission to that entity, but they still dictate fully the course and direction that it takes.
That I hear you, and that's a fact. The thing is you've asked for certain information about that fact. You've got some of it or most of it, and not some of it or most of it. That's what we're here for. That's what your complaint is about.
Yeah, this isn't about going other places.
No, I'm sorry, sir. That it is about going other places.
No, they've indicated.
I am sorry, because that is the way the city runs.
Sure.
And some people have documents and others don't. And the ordinance provides for an assistant. It's not up to us to determine how the city operates and runs its business. So that is not in our jurisdiction. We will not adjudicate on that.
Yeah, I understand, but I can say this categorically. It's in the record. It's a voluminous record here. But they've said effective August 31st, they would produce the documents. That came from them. Now they're saying something totally opposite from what they've read. They said they would have the documents no later than August 31st. That is in the record. I'm not arguing on the other issues.
That's fine. So we're going to
they waive any other issue.
We're going to take that and make that part of our deliberations of whether there's a violation or not.
Yes.
Okay. All right, members, how do you want to move this forward?
I'd like to see in what page that email is that the Art Commission supposedly said they were taking responsibility to get all documents from all departments.
So, Mr. Williams, does that exist somewhere
Yes, it
in the record here?
Yes, it does.
In our packet?
Is this the one on page 406?
406?
Yeah, 406. Where it says, where Ms. Patterson says, I did in fact speak with the city attorney who confirmed that I should help assist you in getting the requested records from other city departments, namely SMTA and DPW.
Okay.
Is that the one, or is it a different
Hold
one?
on to that. Let's
Okay.
see what he produces.
Oh, here it is. I am in the process of responding fully to your request, and I am confident that we will meet the deadline of August 30th.
That's the same page.
The same page. Okay. Thank you.
I rest my case.
Okay. Members, we want, go ahead, Member Josh Wolf.
I mean, I don't have a motion because it feels to me like basically there's any number of city agencies that have any number of these items. It feels to me like it hasn't really been completely parsed through what the holdup on each document is, and I don't know where it was at the end of the complaint committee process when it came to us, but I feel like there's still more sorting to do, and I'm not sure that this is the place to do it.
So I think the letter on 406 is pretty clear. I mean, they made a statement that they were going to meet a deadline. They also said that they had gotten advice from the city attorney who confirmed to them that they should help him get records that they don't have from other city departments.
But it's through the chair, but the last paragraph definitely, again, this is, the both sides of it. The last paragraph states that SFMTA and DBW ask that you please submit a separate request so that they can assist you.
Who is you in here? Oh, so it's Mr. Williams.
Yes,
I see. Because it's directed to Mr. Williams.
Yes.
Okay. All right. So, how do you want to proceed? Member Moss.
I mean, I just want to say that probably one of the big problems that's making this very difficult is that the Arts Commission accepted this IDR through a third party. That what we have originally is an IDR that seems specifically tailored for a nonprofit, and that by handing it over to the Arts Commission, there's just things in here that the Arts Commission just wouldn't have access to, and it's difficult to figure out how they should respond to it. If the Opera House had just told Mr. Williams, listen, we're not subject to the Sunshine Ordinance, you should file a request with the Arts Commission, then the Arts Commission would be able to more easily respond to this rather than running around through a bunch of different agencies and trying to figure out what's applicable and what's not, which has created this whole mess that we're trying to unravel now. And it has complicated it for me in my head. How do we calculate an IDR when the RDR wasn't originally submitted to the organization responding it?
Well, that was how I opened this. Is the Arts Commission assumed responsibility for and that was how DCA COLA also presented it. That this was a
yes. And I understand that, but I mean, I'm a bit confused of what day they actually received this request. I'm very lost in
August 17th.
On the 17th.
If you look at page 395 of my memo, it summarized the email, the date of the email, saying that on August 17th, 2017, Ms. Patterson sent a response email to complainant in which she invoked a 14-day extension to respond to the complainant's IDR. She also informed complainant that some of the records sought in the request were within the control of other city departments, such as Municipal Transportation Agency and the Department of Public Works, and that she would forward the IDR to the custodians of record for those departments and send them an email introducing them to complainant.
And then what is DPW and SFMTA supposed to respond to this? Because by the time they receive this request, it's like a 3-jump IDR to them. I mean, it feels like this whole thing is it's like the Arts Commission tried to be helpful here, and that's just caused this whole ballooning. And if the Arts Commission had just said, like, this has to come directly to us from the requester, it can't come.
Again, the question under 6725, when it's voluminous, is that there's the opportunity to provide on a rolling and incremental basis as the information is found. So if you're doing a deep search on something, you don't know if something exists or not until you find it. Then when you find it, then you produce it. But there's no requirement for it to all be given within a 10-day period or a 14-day period, whatever is prescribed by the law, because the IDR provisions allow that.
I mean, I understand that, but I mean, I don't know that an IDR I understand that an IDR request was accepted. I don't know that an IDR request was submitted. Like, that's what I'm really struggling with here, that while they are honoring this IDR request, I don't think, I mean, as far as I know, Mr. Williams never submitted an IDR to the Arts Commission.
I understand that. The issue here is, and that's what DCA COLA was expressing to us at the beginning of this, is that they assumed it on behalf of that nonprofit. Is that correct?
They took responsibility for the IDR. They then informed the complainant that some records weren't within their control, and then they forwarded the request and made an introductory email elsewhere. And, you know, in a roundabout way, 12L does come into play here. So, I mean, records that a nonprofit has within their control that they're required to keep under 12L are subject to disclosure. And if the Arts Commission had those records and they provided them, then I think it's likely that they complied with the request. As far as other aspects or other financial information that's not required for a 12L entity to keep, if it's not the Arts Commission's obligation to maintain those records, but the complainant could go directly to the nonprofit entity and ask them for those records. And if they don't comply, they could go back to the Arts Commission, and the Arts Commission can act as a mediator in that. And then he could refile a request a complaint against the Arts Commission in that event, in which this body could provide an advisory opinion. Okay. But I mean, it seems as if the Arts Commission tried to get around the convoluted way that 12L works by just honoring the request on their own. It seems as if the complaint or the request was for more information than under 12L that the information needs to be stored. So I don't know whether or not those records exist. If they do, they're probably within the control of the nonprofit entity. But I mean, whether or not there were records that the Arts Commission was required to keep, and they didn't provide those, then you have to establish whether or not they should have provided those records and they withheld them, or if they don't have those records and they should have, and in which case then it would be a failure to maintain. But I think that's the direction that you guys should be focusing on now, is whether or not records that they should have had were disclosed, and if they weren't, do they have them in their possession and they failed to state a reason that they didn't disclose them, or if they just failed to maintain adequate records.
Okay, so one thing is we have a document in writing claiming confidence that they'll meet a deadline to produce the documents by a certain period of time. So why is that taken out of context?
Because I just want to say that was a whole there was a whole exchange between myself and Mr. Williams where I introduced him to the other city departments that had records, and then he came back and he said, I refused to do that. And I said, well, I've asked the city attorney. I clarified, what our role was vis-a-vis the city attorney, and then he sunshined me for all my correspondence with the city attorney. And it was basically, I'm talking about the Arts Commission's records. I am not talking about the other cities. Okay, I just want to make it clear that
I understand that.
I never promised that.
But, Ms., before you leave, I just, I'm reading what you have in writing, so that's submitted in the record. Okay?
Right, but that is like a courtesy. I mean, I just feel like it's being overanalyzed and it's out of context, and I just don't think.
I am confident that we will meet the deadline of August
for our
30th.
records. For
That's
our
fine.
records. Okay.
That's what I'm talking about. I'm not talking about all the other records that you don't have, but the records that you do have. Okay? So that's the first point that we need to focus on. The second point is trying to get through what records were received and what records weren't received.
From whom? That's
right, and from whom? I know, but the point here is this is now the focus is on the Arts Commission. I think I can speak for the task force that we don't ever believe that any one particular department has all the information. That the information, lots of information lives with other different departments for various reasons, and that is the purpose of the assistance, which they in their words here, were told to do by the city attorney, which seems like that they made some attempt to do that. I've done tons of this, requests too, as other people. I mean, I'm never going to get all the information from one department. If it's about the freshwater delivery system that's part of the reclamation project in the Rec and Park Department, well, part of that is Rec and Park, and part of that is Public Utilities Commission. The Rec and Park's only going to have so much information, and then they're going to say you're going to have to go talk to PUC and get the rest of the information from them. Then I file a request with them, and that's the way it works. Okay, so there's no guarantee or how should I say, there's no express responsibility that one department provide all the information, especially if it's coming from other departments. That's why the clause in the ordinance talks about assistance. Okay, so I think that it needs to be said. What I want to do, because we've gone on for quite some time, and I feel like I don't want to rehash what has and what hasn't. If somebody feels like they want to make a motion for a violation, let's do that. I think the rest of it, as far as figuring out what information has been received and what isn't, should be referred to committee and have committee go through that and determine and come up with a recommendation.
But if the information that hasn't been received is from SFMTA or DPW, there's not been a request by a complainant to those departments.
But the point is trying to find out whether the Arts Commission has provided all the information that they have first. That's the crux of this complaint.
And that would,
anything that's not applicable, that's something different, and Mr. Williams then will have to file separate requests with those other departments because they're the custodians.
Right.
Somebody there has those, and that's the way this works. So there's not one big repository, not yet.
Yeah.
We're getting there close, but we're not there yet.
That I needed from SMTA, nothing relevant from DPW.
Hey, please come up to the mic so
Maybe
we get this on the record.
maybe we can start rebuttals at this point.
Okay, just please.
You're running this. I'm going to respect it.
Okay, so I just want to. The point here is I understand what you're saying and what your research is. Okay, what I'm trying to do is get closure here for the task force.
Sure,
okay, because we have to find some way to close it. We can just say, look, the information that you got is what you got, and the information you didn't get isn't with that department, that the Arts Commission, and that could be the end of that. Okay?
Yes.
I'm not speaking on behalf of the rest of my colleagues here. I yield to them to make the motion so that we can move ahead. So I want to give Member Moss an opportunity. He hasn't spoken that much.
So I'm trying to learn more about how 12L works, because I think this is maybe the first time it's come up since I've been on the task force. Okay. And I wanted to ask DCA Cole about 12.5B regarding dispute resolution over these kinds of requests. As I'm reading this, a member of the public who requests additional financial information other than that described in 12.5A above, or has a complaint concerning a nonprofit's organization's compliance or non-compliance with this chapter, may submit that request or complaint to the city agency or department which is party to or which administrates the nonprofit's organization's contract. The city or agency or department shall consider the request or complaint and shall recommend a resolution thereof in accordance with procedures established by the city agency or department. Following such consideration recommendation, the member of the public or nonprofit organization may seek an advisory opinion concerning the request or complaint from the Sunshine Ordinance Task Force. And then it just talks about what we are authorized to do. So my question here is that whether the proper process for all of this should have been for the complainant to have gone through this process with the Arts Commission, and the Arts Commission having then, recommended a resolution, and then if the member of the public was unhappy with that resolution, then he should have come to us with this. I'm wondering if this whole process, if there is a process for resolving this that just wasn't followed by the Arts Commission in the way that the Arts Commission handled the request. So I'm just not sure about. I just see 12.5B. And
how should we move forward? I need your help here to determine how we should move forward.
Does DCA Cola have? Am I reading this right, or
no? You're reading it right, but by accepting the complaint or by accepting the request, it brought it within the realm of Sunshine, and the complainant filed the complaint against the Arts Commission, so it brought it within our realm. It's before us now.
Are we able to consider it without them having gone through the process of getting a recommended resolution from the Arts Commission? If we need to send them to figure out a resolution with the Arts Commission to get these things, then that's the motion I want to make. If that's what 12L.5B requires of us.
I mean, if all the parties here agree to it, we could ask them to. We could ask them if they're okay with treating it as if it's a 12.5L, and then they can confer with each other about how they want to handle the missing information, and whether or not perhaps the Arts Commission wants to reassess its future granting to an entity that maybe doesn't maintain records in a way that they find to their liking.
The one thing we also have to determine is if records first exist, are they public and publicly disclosable, without exemption. That's also before us also.
Yeah, I'm confused here too, because it seems like just by going through the list of what's not there, that a lot of information has been provided by the Arts Commission, and they're saying that's all the information they have, and other departments might have other information. But other departments have not been requested by the complainant, and I don't know if the Opera House has provided anything on their own for whatever they have. So I don't, if we're dealing just with what the Arts Commission has done, I mean, I don't know, maybe I could see a violation of immediate disclosure of 6725, but then I don't know how that accommodates the complainant getting other records. And maybe that's not our task right now.
I think that, again, bring the focus back on who's here in the room. It's the Arts Commission. It's not DPW. It's not MTA. So if they have documents that are part and parcel, or the Department of Real Estate or the city administrator, but if they have documents that are part and parcel to this gentleman's request, then that is a completely different thing. So the first thing, again, is we have to determine is what documents do the Arts Commission have? Did they provide those? Did they provide them? Did they provide them in a timely manner? and were any of those documents withheld? And if they were withheld and the petitioner has knowledge that they've been withheld, then there has to be a reason from the Arts Commission as to why they were withheld.
Yes.
That's correct. I want to get conference here with these
Sure.
guys because we got to bring this to a close somehow, okay, and find some way forward. Okay, so so I would like to bring our focus in on those points. Okay, so let's take I'll drive it. Let's take the first point. Was this done in a timely manner?
I don't think so,
Okay.
according to an IDR.
Okay. Were all the document? Go ahead, Member Jeff.
I mean, it was. First off, there's this element of the IDR was actually to the Opera House, not to the Arts Commission. So I'm not sure how to actually process that in terms of the timeliness. In terms of timeliness, they received the IDR, they acknowledged that it was a voluminous request, then they asked for an extension the next day. That extension that they asked for was a 14-day extension when it should have been a 10-day extension. But earlier people were saying they weren't concerned with the 14 versus 10. But that's the only element of timeliness I see, is that they got 14 days when they should have only received 10.
If I can clarify that for a second, just the government code 6253, which is what this is based on, speaks to general requests shall be response within 10 days. If it's an unusual circumstance, and it goes through what that is, and that's the voluminous, then it would be extended just by 4 days. Okay? Either way, there was activity from the Arts Commission for that extension. Okay? 10 days or 14 days, whatever it is, and within the document that says that for the documents that they were concerned about, that they knew that they would complete by August 30th, which is beyond the time, that kind of thing. So there's that portion right there on timeliness. Okay.
All right, Member Wolf?
Yes.
So I'm just being mindful of what our quorum is like now, and I'm not feeling confident personally of voting in favor of any violation today. And I don't. Before you guys get into too much discussion, maybe it's better to continue this or move this back to the Plan Committee.
That was what I was going to suggest, because I think that I think I don't feel that anybody's got a definitive motion they want to come through on this, and there's a lot of questions on this.
And through the chair, do we need to explain the quorum issue to people who may not know about it?
Okay, so the way the quorum works, it works the same way as the Board of Supervisors. It's got to be a majority of the number of people who are actually seated. So there are 11 seats. We need 6 to have a meeting, but we need 6 to also approve.
Yeah.
Okay, so we are 2, 4, 6. Okay, if there's a motion to find a violation, one person could vote no, and that's that. So we generally express that that's an important factor for a lot of people, and some members feel uncomfortable not having enough members at the table.
That's understandable.
Okay,
that's understandable.
I mean, I don't want to be.
I generally would. I'm trying not to allow these kinds of cases that get complicated in the weeds to go this far along, and it would generally stop at an hour ago and say, let's move for a continuance and figure out what do we need in order to be able to do that. I think if we're going to do a continuance, let's get something on the table concrete that we want that will help us make a decision. Okay? This is not. And I appreciate what you're going to say, okay, but this is really what we need in order to keep our focus.
Yes.
And I would prefer the parties not to tell us what we need.
Absolutely.
Okay.
I would only suggest that you look at the record. Just 1 minute. There is another email between Ms. Patterson and I, where she, without condition, says we'll get this information to you. Then the next day, she says, I consulted with my colleagues, and you may need to contact them on different departments. So she, out the gate, she says she's going to do it without conditions, without me going to other departments. Then she changes her mind the next day. So I think that's probative in terms of looking at the record. So I had a reasonable expectation. So then after that, I said, I refuse to do this because it seems like there's a game being played. And again, let me underscore, I don't need anything. The community didn't request anything from the SMTA because that's a bus stop lane. The fencing is the Department of Public Works. What we're asking for was the substantive aspects of the Opera House has a board. It has an executive director. We were asking because the Arts Commission tells them what to do. The email shows that. So we're just trying to get the information from the most readily available source that funds them. That's reasonable. I've seen that done.
And I mean no disrespect in cutting you off.
Yeah,
really. I'm getting a little tired personally, just because I haven't eaten any dinner tonight, so I'm getting a little tired. So I just want to be able to. I think we need to continue. So I don't send. If I had to do a straw poll, I don't think anybody would raise their hand for or against. I think there's a lot of abstention here. So
to me, criteria for continuance now, since Mr. Williams said forget SFMTA and DPW, is to have the Opera House or the Arts Commission work with the Opera House to produce any other records that they haven't produced that are public.
But you see, that's where 12L comes in. You can't compel them to do that.
To ask.
You can ask. They don't have to provide, but that's the way it works. Remember, Josh Wolf.
Mr. Williams, as you may know, although we do have an ability to find violations, our teeth aren't necessarily sharpened as sharp as one might like. And so while there may be a potential violation we find in the future, it seems to me that your first interest is obtaining any of these documents that you don't yet have, and whether or not you should need to reach out to other city departments to get them. By the time this comes back to us, that'll have been at least another month that perhaps that you won't have those documents. And so I just encourage you to reach out to any possible place that these documents might be so that you have them. And that in no way changes your rights to file a complaint, but it does allow you to potentially get what you're looking for before our process actually reaches its conclusion.
Gotcha. I appeared November 6th before the Arts Commission, brought my attorney, Mr. Emmett Gilman, who's a San Francisco attorney, and said, I'm willing to mediate. No response. The last two people from the Arts Commission are right here. So I showed up. They know I was there, saying, let's work this out. Well, if they don't want to go out on a date, I can't make them.
Mm-hmm. So I just want to say, members, that if there's any enforcement that we do have, it's not really kind of like enforcement, but it's to compel. And it falls under the under 6721, which is kind of the basis for that 6725 is an extension for. And under 6721C, in smack in the middle, it says, upon determination that the record is public, the Sunshine Task Force shall immediately order the custodian of the public record to comply with the person's request. So just want to say that if the respondent is claiming that the item is not public, but we determine that it's public, that's when that statement gets activated, okay? It's not necessarily that a document doesn't exist. So a lot of people mix this up because they think that we have the ability to, just compel ad hominem on anything, and that's not the fact. It's when there's a resistance to release something saying that it's not a public record. So I don't think there's any resistance by the Arts Commission to not provide you with information in that way. The question is whether they have it or not, and that's where I think our continuance, the basis of our continuance, is got to be.
And again, I'd be willing to work with them in the interim.
I mean, if you guys are, that is our primary suggestion and hope is that parties will try to work together to do that. And in the past, when there is agreement to do that, we will have you report to the Compliance and Amendments Committee to see how it went.
I appreciate your time. I really do, and I thank you so much for taking out the time.
Okay. All right. With that, members, what should we do? Go ahead.
Can they come to Compliance and Amendments without a decision here, just as a continuance?
We can as a continuance to help if we want it to be part of the facilitation to try and work this out so that way both parties can feel assured with a quasi-mediator, so to speak, to make sure that all the documents that can be gotten are gotten. And if, but parties have to agree to that. Member Josh Wolf, and then go ahead, Member Kanata.
Through the chair, Member Kenyatta, Compliance Amendments meets in January, correct?
Yes, or the odd months.
And as chair of Compliance and Amendments, do you think you could schedule this in your upcoming meeting in next month?
That would be through Victor, the scheduling of it.
No, but it's not the question. The question is do you think your committee can take the time to do this?
For January, that's
Don't look at me, you're the chair.
Well, that's a couple of weeks with holiday. So I'm not sure.
I would just like to state that there is some of the dates are up in the air regarding a special meeting for the full Sunshine Ordinance Task Force, where we may be bumping the Compliance and Amendments Committee to a different date in January.
That's okay, as long as it happens and parties can be assured that there's a forum.
Right, but
all right, to make what I said a lot simpler.
Okay, one person at a time.
One condition would be that it would only be records that the Arts Commission has. We're not dealing with the Opera House or any other entity.
Right. We're only dealing with the Arts Commission.
Okay.
And if the Arts Commission says we don't have those documents, but the Opera House organization has those, then, a request can be made. They can comply or not comply if it's outside the scope of the requirements of 12L.
And we would also like I would also like the list that Mr. Williams had about what was received and what wasn't, that is not in our document now, to be in our document as soon as possible, so that we can go through that list and try to figure out what would the Arts Commission possibly have.
Right.
So I think it would be great to see it move over to Compliance Amendments to kind of push this process along. My gut tells me that there are still documents that are public documents that he hasn't received, but it doesn't appear that the Arts Commission necessarily is the one in possession of them. And so whatever work we can do to help facilitate Mr. Williams to get the documents he's after feels like the best use of our time, rather than spending any more time trying to identify who broke what rule and when.
I agree.
Okay, so is there a motion?
I'll make a motion to send this to Compliance and Amendments in dealing with documents.
To do what?
To work with both parties to work with both parties to make sure that all the documents that the Arts Commission has have been produced.
Okay. Member Josh will second it. Okay. Members, any other discussion on this? No. Okay, let's go to public comment.
Did you want to allow them any kind of rebuttal?
Oh, yes, we must provide them with rebuttal.
Do we? If we're just moving it, we're just continuing it?
Well, we're going to continue, right? Yeah, I mean, it's part of our complaint process. We normally wouldn't make a motion until after rebuttal, so let me just ask, do you have any rebuttal? Any parties, do you have any rebuttals? No, okay. Okay. So respondent goes first anyway. 3 minutes for rebuttal.
Thank you.
Do this.
I just want to just re-clarify a number of points. Number one, We accepted responsibility for the records that spoke directly to records that we might actually have with regard to this request. We inquired as to what the responsibilities of the nonprofit were and had those clarified in this process. I did outreach to departments that I knew possessed records related to the construction of and the renovation of the Bayview Opera House on behalf of Mr. Williams. I did not accept responsibility for the full universe of documents, including those held by other city departments. I worked incredibly thoroughly and diligently to the best of my ability to ensure that every document responsive to each item was provided to Mr. Williams. If we did not have a document, we said no records. We had no records. I don't think, if we redacted information, we provided the proper legal rationale. We did not withhold anything inappropriately. We are happy to go through line by line and clarify with Mr. Williams what records we would have and what the nonprofit would have. I think there's a lot of confusion about who has those records and what the Arts Commission is responsible for with regard to the nonprofit. And so we're happy to work with him through that. Again, I turned over the records that I happened to receive from the Department of Public Works. I have no idea if they're totally complete. There were aspects of the project that were managed by the SFMTA. I did make that introduction. I never received any documents from the SFMTA, so I'm just bringing this up in the event that Mr. Williams wants to reach out again to the SFMTA with questions related to this project. And with the exception of the additional records that we found after the first hearing, I maintain that we were transparent and that we turned everything over to Mr. Williams.
Thank you. Mr. Williams, 3 minutes.
Okay. Members, there's been a selective disclosure of records. They tell the Arts Commission pretty much what to do. 7:48 in the morning, Tom DeCaney, her boss, calls the executive director. I don't know what could be more definitive as proof of who tells what to do. And to leave it to where there is a shell game, leaving it up to the Arts Commission to say, well, we don't have those documents. You got to go over there to the very people they tell what to do, what to disclose. Now, if it were not true, then it would have been Ms. Okel that would simply have written me to say, we are a nonprofit. We don't have to disclose these records under 12L or whatever reason. What happened instead, according to the facts? She was contacted by the Arts Commission Director of Cultural Affairs and told what not to do. The ordinance is abundantly clear on the department heads and employees interfering in a request towards the denial. Now, if Mr. DeCaney had said, well, you ought to give Mr. Williams this, you ought to give Mr. Williams that would have been perfectly acceptable. They assumed responsibility. So they waive any other disclaimer that the onus was not upon them to produce the records. They fund them. They control them. He who has the money makes the rule. They give them the money, and the Arts Commission makes the rule. So to think anything less is naive. It would lead me and the community down a rabbit hole if you were to say, well, they'll tell me tomorrow, we don't have those documents, but they can do what Mr. DeCaney did. Go to the executive director of the Opera House and say, give Mr. Williams what he wants. Beyond that, I believe there's an ethical duty that exceeds the letter of the law. My name happens to be Williams. My mother's name happened to be Williams. Thank you.
I would like to clarify the motion before we proceed.
Sure.
The motion is to refer the matter to the Compliance and Amendments Committee. And the goal of the Compliance and Amendments Committee is to review the list to be provided by Mr. Williams to determine whether or not the Arts Commission has provided the documents in their possession. And this is related to the Arts Commission only.
Shouldn't there be a continue the item inside of that motion too?
We can refer it without continuing.
Yeah.
Okay.
Well, we should formally continue the item because we want it to come.
I believe all we need to do is refer it, and they will refer it back up.
Well, the case is open.
Yes.
Okay, so if we're not going to take action on it except to have committee review something, it's just continue. It's continuing.
It doesn't make that's fine.
I would suggest that
we can continue and refer.
Continue and refer. The purpose of continuing.
I'm fine with that.
Okay.
And
all right.
Second. So.
Everybody okay with that motion? Member Moss?
Are we public comment now?
Yes,
Okay.
we're going to do public comment now. Just want to make sure that we're okay on, so the public knows what we're deciding. Okay, public comment.
So, board members, I think this is a very convoluted and very boring meeting. Now, having said that, this issue happened because of discrimination. A black woman went to this white woman, Barbara Okel, and asked her that she wanted to rent the opera house. She said, "We don't rent it to animals and goons." This perturbed the community. And so what I see here is like y'all are trying to put the onus on some documents. And some statements have been made here, first by this woman, Ms. Patterson, that we are a peanut gallery. And then by this attorney who purports that it's within his power to defend whoever he wants to. We pay your salary, Mr. Attorney, and you represent the people. But if you want to take sides, then we know how to deal with you. We really know how to deal with you. So I'm saying this because this happens again and again. If white folks came here, y'all would have cleared this very, very beautifully. But because you have a community that is in pain, suffering, the Bayview Opera House took so long to be remodeled that over 60 young men were killed because they couldn't use the Opera House. Because of this art commission and all these goons, they are the goons who were behind controlling the money. And these people who control the money, we need to take them to task. We know who they are. So next time, if 60, 70 people from the community come, they will not be lenient as I am. You think I'm a little bit harsh. We know you, attorneys. You are supposed to represent the people. Your heart has to be in the right place, not in the wrong place. Much like what happens in Palestine. Thank you very much.
Thank you. Any other public comment?
I have several things I want to say. The heart of the matter in this complaint is that Kate Patterson doesn't know or understand the Sunshine Ordinance. If she had understood it, she wouldn't have taken the complaint. You also notice what she did during general public comment. She ran into the well when I was speaking and whispered in Victor's ear. Don't know what it's about, but obviously she doesn't understand general public comment. And then her comment about me laughing in the peanut gallery. She wants to walk out, knock yourself out. Okay, so as far as this complaint, the immediate disclosure request, which is in 402, 403, the thing that is most disturbing to me is copy, bids, documents. Yeah, 13. Produce conformed copies of any and all documents reflecting donations of food, liquor, and wine, including but not limited to any other source of donations for anything else properly related to the Opera House goals and objectives. It's a different way of saying a requirement under the Sunshine Ordinance, which is any donation over $100 must be posted and listed on their website. I know because I got them violated for that 2 years ago, and they still have not complied. That's how I read that part of it on page 403. I don't know about anything else. I can't speak to it, but obviously this is a very subjective thing, and the text that Mr. Williams keeps referring to, it said right at the bottom of it, subject to attorney-client privilege. This is another mistake on the part of Kate Patterson. It should not have been included. It's attorney-client. So all these discussions tonight and everything that I've said for the past 5 years is this woman needs to be educated. If she's the custodian of records, you've heard her talk. We've all heard her talk. We've tried to decipher. She doesn't understand the ordinance, and that's why we spend so much time here.
Any other public comment?
Good evening, everyone. My name is Teresa Wallace, and I'm a native San Franciscan. And I started dancing on the stage at the Bayview Opera House at 5 years old. And you talk about culture. I want to know where the cultural competency is. How can she tell me about my culture? How can the whole board tell me about my culture? You did not advertise to the community that a position was opened, and you put a German white woman to dictate our culture? Really? But better yet, on September 23rd, 2017, I gave my 60th birthday party there. And my coordinator for that event, she fired because he was trying to help us. 3 times she tried to go up on the fee for that event. There's so many things that's going on. I was in the office 3 times when she refused community individuals to give an event there. Now, it's our children being shot down in the street. How come we can't go to the Opera House and talk about it? It's our children that's being abused and neglected in the San Francisco School District. How come we can't go to the Opera House and talk about it? If that's our cultural center, where do we go? You wouldn't go to Chinatown with that. We can't go to Chinatown and African dance, can we? No. We can't go to the Mission and do our cultural stuff in the Mission, but you let everybody in town come to the Opera House. I got an issue with that. Thank you.
Thank you. Any other public comment?
My name is Salah Haquir. If you can, tell 1,000 words and show where that was performed, show the name of what that is. And I think it's very unfortunate. My name is Salah, and there it is. I think it's very unfortunate, and bring it down, that this is supposed to be our culture. This was put on by the Opera House, the Players and Pimp Award at the Bayview Opera House. I want you to see this grand disrespect. It's no way on earth that you would have this at the Opera House on Van Ness. Now, I've been watching Barbara for 5 years since she's been there, and I want you to hear it too. I've been an activist in San Francisco. My name is for 38
don't hold the mic.
38 years. I've been fighting for this community for 38 years. I never questioned Barbara because of her skin color until an article from the Bayview newspaper in the November article, just passed. And the request was for her to provide, the request was about Ruth Williams Memorial Theater. And her statement was, Ruth Williams, if this is who she really is and her contribution to Bayview and everything that you say that Ruth Williams did, which was in 1966, there was a riot when a young man named Matthew was shot in the back, about 15 years old. And Ruth Williams was inside that Bayview Opera House. And the National Guards, 2,000 came in, thought it was a sniper on the roof, and shot that building up with all our black babies up in there. And after that building was shot up like Swiss cheese, you can Google it, the city was getting ready to demolish it. And it was Ruth Williams who said, no, this building needs to stay open because these children need a refuge, a place to go. And I want to say to you that she fought, she begged, she cried and asked for the city to help her so it would not be demolished. They was going to demolish it. And she eventually got the support. And then when she passed, the building was named after her. And I went to Barbara and I said, Barbara, you don't even have a picture of her up here. White woman. Then she went and put a small little picture like a matchbox about the size of this right here. And then in the article, she's going to have the nerve to say, if all these contributions are true, then send her the information. It's all there, email word by word. If it's true about this Ruth Williams, the same thing that I'm hearing here, show me. I don't have the documents. Cover up. You can't be in the position that you are. It tells you to seek and you shall find. Knocking the door should be, but don't tell me what you can't find. You're going to be the responsible person to be in charge of the Ruth Williams Memorial Theater, and you don't know who Ruth Williams was. And now we're supposed to prove to you who Ruth Williams was. My son was just murdered on San Francisco streets. And I'm going to be quiet. On San Francisco streets, my only son was just murdered. 19-year-old, the quadruple homicide that just happened in Hayes Valley. He was a young man that was trying to just cash his check at Benihana's Japanese restaurant, and he was just shot to death, January the 9th, 2015. That is a place for our children to go and to learn of art and culture, and it's not being represented. It's a great disrespect that's taken on there. And so I wanted to come here so you can at least have an idea of what's about to happen. We are requesting that she be removed.
Thank you, ma'am.
Thank you.
Any other public comment? Seeing no public comment, please call the roll.
On the motion to continue and refer the matter to the Compliance Amendments Committee, Member Kanata.
Aye.
Kanata, aye. Member Josh Wolf.
Aye.
Wolf, aye. Fisher, absent. Member Hinsey.
Aye.
Hinsey, aye. Highland, absent. Excused. Member Eldon. Aye. Eldon, aye. Copra, absent. Tesfa, excused. Member Moss.
Aye.
Moss, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Thank you.
Member Wolf?
Yes.
Or Chair Wolf, can we take a restroom break?
Yes.
I would get up and just go.
Can we
bring things to a standstill.
10 minutes?
Sure.
Okay, great. Thank you. We're in recess for 10 minutes. Bring it back, folks. Oh, that's fine.
We're back on the record.
Does your bank have a 24-hour?
Okay, let's call the next item.
Next on the agenda is item number 8, file number 17105, hearing to review legislation and policy at the federal, state, and local level, as well as other jurisdictions related to the Sunshine Ordinance and California Public Records Act. I believe that Member Moss provided us an article regarding online portals, regarding their slowness and difficulty of use.
Okay, and why is there a roach on this page?
A what?
A roach.
What?
I see it.
Oh, sorry, I was very confused. That is the article, that is the photo that went with the article. I don't know what to tell you.
What's the significance of the vote?
I have no idea why they put that on there. I just sent a link.
Okay.
So I didn't PDF this
Okay.
article.
Is there anything you want to present on this?
No, so I know that we just had some discussions about next request, and we'd had some hearings on it, and they came in here, I believe we had a presenter come in here talk about how great next request was and how these portals were going to speed up things, and I just thought it was important to provide what seems to be the shining example from San Diego is not as shining as they would like it to be. This was just for informational of interest for anybody who's been looking at this issue.
Okay. Any other news? Any bills or legislation come up?
I have heard zero. I've heard zilch about the next session.
All righty. Any discussion on this item, members? There's no public in the public area for public comment. So we'll move on to the next item.
Next on the agenda, item 9, file number 17103, review and possible amendments to the Sunshine Ordinance Task Force bylaws and complaint procedures to review and revise the following issues. I believe at our last meeting, we did amend our hearing procedures to eliminate the word the committees from the hearing procedures list so that it only applies to the Sunshine Ordinance Task Force and not its committees.
Right.
Next on our list to consider is our procedures for reconsiderations of order determinations. I believe that our current description is a little bit light on requirements, and we should clarify it to make the procedure run smoother in the future. And my suggestion is that we should insert a limit on the number of times that they can reconsider a specific complaint.
Okay.
Don't we have to approve the reconsideration anyhow?
Yes, we approved the reconsideration, but the question is it provides the administrator the ability to disallow at the front door how many times a person. His suggestion is to create a limit. So at the front door, there would be.
How many?
So that, and this is a reconsideration applies to either party?
Either party.
So we could have a ruling and vote for the respondent, and the complainant puts in new evidence, and we vote for the complainant, and respondent puts in new evidence?
Well, no, it's based upon, first of all, there's a time limit as to when you can actually, it's 10 days of the receipt of the order determination. Actually, I think that should be changed. Because the time factor of when an OD is created and to the time that it gets signed, I think it should be at the end of that meeting where the decision was made, not when the document of the decision is delivered. So I'm looking on page
706.
No, 690. 692.
692?
It says the committee reviewed, oh no, that's part of the minutes.
Yes, it is part of the minutes where the committee had recommendations on how to amend.
Right, so the committee reviewed the process for reconsideration of complaints, and then it says within 10 days of receipt of the order of determination.
Right. But the only reason we would hear a reconsideration is if there was new evidence, right?
That's right, but we would determine that. The question is how many times can a person reconsider?
Right, but I thought you said changing the 10 days to the...
No, I was saying leave the 10 days, but...
10 days from the day it was adjudicated.
Adjudicated,
okay.
right.
I misunderstood.
Not from when the paper was delivered. And so it says receipt of order determination. To me, that means when I get the paper. So I think that should be within 10 days of the hearing.
Right.
I don't agree with that.
You don't agree with that?
No, I mean, I feel like, with procedure, it's when all said is done is when it's actually memorialized, and then somebody has a document to look at, and maybe there's an error on the order of determination or it was phrased differently than they remembered. But I mean, remember, it takes a while for our audio to go online. It takes a while for the minutes to be finalized. And so if somebody is having to do a motion for needs to file their reconsideration thing based on their memory of what was said here, I feel like it's better just to wait until everything is formalized, and then that is the timing they work off.
But they are here. They're here. If they didn't get the outcome that they had expected, they would immediately within 10 days file for reconsideration.
Why
should it wait? Why the point of doing that is they may get because all the documents may come later on. I don't know why there needs to be any review of any documents if they didn't get their way.
I don't know. I feel like that the order of determination is our opinion, and that it's not necessarily what we voted on. It's the opinion is what we've written down, and that the person needs to be able to look at the written record, not at what we had just said. And I mean, that's my thought on it. Like, I mean, a judge may rule in a case, but I mean, it's the actual formal finding that the judge puts down that is what you.
I know, but I don't know when so Nick, when does the clock start ticking? I mean, let's take the example in a court. So judge makes an order. Okay, the paperwork that shows the opinion and what the order is comes 25, 30 days later. When does the clock start ticking when you can appeal? Is it at the hearing date that the judge made the order, or at the date you received the opinion in the mail?
Well, you would wait until you get a written opinion so you could actually appeal on the basis of the specific information in the opinion.
Yeah, but you would know if it was by the order that was made by the judge at the time that you're there, whether it was in your favor or not in your favor.
But you can't start writing that appeal, like having...
until you know what you're actually going to contest.
Having had the Ninth Circuit rule against me and been waiting for the paper to be published and talking to my lawyers about their appeal, I know for a fact that this is an issue that, like, you can't actually start working on the appeal until you get the opinion in your hand, because it's just there's nothing to work with.
But our process is only that they can file for reconsideration because they're going to come with new evidence.
But the order of determination is our memorialized process of a decision, and so, like, ideally we should print out order of determinations like at the meeting, which would resolve this because they'd be like immediate. But that is the document that, like, let's say there was some confusion. You thought it was these two violations. The motion got talked about a bunch. Like, the order of determination is what you're appealing.
Okay. I mean, you could say the draft minutes are that. It's in writing, has the order in there. I mean, the opinion is, it's really just a motion based upon the complaint that was brought forward. If they don't like the response based upon the result of the motion, I mean, all the facts and evidence have been already presented.
Do we have an issue of, like, not timely reconsiderations that we need to, like, get this timeline precise?
I think the first question that Victor was bringing up was how many times a person can make a reconsideration on the same item. Is that what you're talking about?
I'm just worried that they'll constantly bring in items one at a time, looking for more information and more.
Okay, so this is a kind of creating complaints in piecemeal, and then of the same person, for the same items, or it's a dragnet of complaints, and that the reconsideration process could be abused. right?
Yes.
Okay. So that's an issue of possible or potential abuse. So how do you stop that? One of the things that we did do was we've done a couple of things. One is we limited how many times we would hear from the same petitioner in any meeting. We've also done combining complaints. So I don't know. I'll go with whatever the majority wants to do
Part
here.
of the amendment to the first paragraph is to require that the party requesting a reconsideration provides an offer of proof with a description of why they believe the new information would affect the decision in writing.
Okay.
Before, there was no requirement that they explain what the new proof was, or.
Oh, okay. So that changes it for me. Okay, because if a person were to find they don't have any new evidence within 10 days, but somehow something pops up in 20 days or 30 days. Okay, that's where that provides a little more reasonable time for me. I think it should be 30 days if we're going to require them to show cause.
Just sort of looking through our orders of determination, we tend to be, about a month before an order of determination is issued from the hearing.
Yes.
So 10 days from the order of determination is essentially 30, 40 days from the actual hearing.
Yeah. So, okay.
I mean, is this something that we could have a process that requests for a reconsideration need to be approved by the complaint committee before coming back to the task force, and the complaint committee has the authority not to forward those up the chain?
That is a new change. In the previous version of this text, only the task force can make that decision. We have added the word committee to allow the committees to also evaluate reconsideration request. That's for your discussion, and
okay,
that was part of the recommendation from the Rules Committee.
Yeah, I do see that it says the task force or its committee here. I mean, if the issues were just getting a lot of these, then we shouldn't be having these hearings on every single one. Have we had somebody ask for multiple reconsiderations on the same item? And is it like we reject the reconsideration and then they come back again?
I just foresee that happening based upon some of my based upon discussions with some parties. I wanted to put that in as a precaution.
People will granulate their complaints. And that's why we've talked about combining them, because they're usually against the same person for the same piece of information, but it's like this one was on timeliness, this one was unresponsive, this next one is for something else. But we created a rule for combining them. And I think Victor fears that there's going to be some twist on that's going to create some loophole, because people will see that there's an opportunity for reconsideration, and they'll be able to, rehash and rehash and rehash. So I'll go with whatever everybody wants. I think it's fair, Member Moss, that, it takes, 3-4 weeks for an OD to come out. At least I get it probably in 3 weeks. And it takes me about a week to read through them all and then sign them. Yeah. That's okay with me. And the only other change was that the information be presented at the time of the reconsideration. That they said they make a request.
From my understanding of the Rules Committee's recommendations, it was to have the party offer proof that the new information would affect the decision made by the Sunshine Ordinance Task Force, and provide that written documentation.
Yeah, I would agree with that in concept. I'm not sure how, if that could be, I mean, I guess they could. I mean, like you write a brief, like a legal brief showing.
Or just state why is this, how does this new document affect the decision of the task force?
Just put it in writing? Okay.
That's a question, not a legal brief.
Okay.
All we need is a couple of lines.
Yeah, okay, fair enough.
And then I do want to suggest, where I say within 10 days of receipt, I would suggest rating it within 10 days of issuance of the order of determination.
Maybe publication of it, so when it goes up on the Sunshine Task Force website, being the...
Do you wait before I sign
I do it all of this. I wait for you to sign it before I
put it up on the website. So
before I put it on the website and send it to the parties.
Okay.
So I was suggesting issuance.
So
It's just
well,
definition.
so there's a difference between issuance and receipt, right? Issuance is the day you send it, and the receipt is the day you receive it. Yeah.
It seems like the point of publication on the web is the point of issuance and is the point that it becomes publicly available. So it seems like that's the easiest time to hone in on.
So what word would we like to use?
Publication.
Publication?
Publication?
Okay.
And so the last sentence there, accept no more than one request.
I would like to add at the end of that sentence from each party, or
So what about how would it be worded? What about the situation?
What page you're reading from?
I'm on
page
692.
Oh, geez, you're on 692. I'm on
Okay.
706.
Yeah, that's what I was.
But in a situation where there's an order of determination against a party, and they come in and they ask for reconsideration, and we give it to them, and then we have another order of determination against them, should they be allowed to ask for reconsideration again?
I mean, if they're actually coming up with actual new evidence that changes the situation, then I think they should be.
Yeah, the question is do you want to allow process and allow the process to work with providing that we make the decision of whether it's valid or not, or do you want to limit process so that we don't, it's less work for us? That's.
I mean, we're also inoculating against a problem that hasn't actually been a problem historically.
Right. And these are very malleable. They're very flexible. We can always, there are rules. So.
Then why limit it if you want the process to be the process?
Well,
it is your choice. These are just the recommendations from the rules.
So I understand. It says the task force will accept no more than one request for consideration per OD.
And I was going to suggest it would be from each party and not just one from the petitioner and one. I leave it to your discretion.
Yeah. Okay. I think the verbiage is getting me off. Yeah.
So as long as we have Victor as our administrator, and we, hopefully will for the foreseeable future, trusting Victor to deny these refusals that are repetitive and don't go anywhere sounds great to me. On the other hand, should we end up with someone else as our administrator that this is problematic, I'm not sure I don't want these requests for reconsideration to go before our desk through that process. Like, I don't know that I want to trust Victor's replacement.
So then have it go through committee.
We can just let the committee make that decision.
Yeah.
The other thing I wanted to say, the way this is worded to me, so we'll accept no more than one request per order of determination. Every time you have a reconsideration, there's a new order of determination. So it would just be it would be an ongoing.
Not necessarily. I think the point here is that if we order a determination and somebody petitions for reconsideration and then we reject the reconsideration, then that would be the end of it.
Right.
Right. But in the event that we have the reconsideration and we come to a different conclusion, then that was what would start the process over again.
No, it's just a new result of the same order of determination.
But it's a new order of determination.
No, it's not new order. No, the purpose of a reconsideration is to change the vote. Change the vote of the item that is on the table. The item is static. It's not new. It's not a new item. It's the same item. It's just new information may compel you to have a different opinion.
So we didn't create a new order of determination in the Clark case when we found for a different violation?
Yeah, I think it would. We need, if we want to do it your way, the term needs to be item, and it can't be or per case. It can't be per order of determination, because anytime we change the order of determination, it creates a new order of determination. We've invalidated the other one. We've created a new one.
Yeah, you're right. So that's why. So if you just take it out of our rubric and just put it into Robert's rules. If you made a motion to build a wood house, okay, and somebody said, okay, I want to reconsider that because I found wood is really bad on coastal areas, it should be brick instead, okay? The project doesn't change. That particular decision doesn't change. You're still going to build a house.
But if you have an order of determination to find no violation, right? And that's the motion.
Right.
And that was voted on. And then the complainant has new evidence, comes in, and now you re-vote on that, and the people think there should be a violation. You're voting, the original motion is to find no violations. That gets rejected. Then you have to have a new motion to find violation.
No, it's not. You don't change the You don't necessarily change the motion. The idea of reconsideration is to change the vote.
Right. So you did change the vote. Now we think. Now the vote on is there no violation is a no vote. So wouldn't you have to have a positive motion?
Not necessarily.
Well, we're just going to.
But then how do you find
violations in by negative yes votes? That doesn't work.
No, the point is if you find in the situation that there's no violation, that's a very specific situation. Yes. Okay, if you find that there's no violation, and a new and compelling evidence comes back to find that there was violation, it's based upon the complaint. So if you think about it, when somebody brings a complaint, think of that as the question. Okay. Is there a violation of 6721 based on timeliness?
No.
If the answer is no, and then they bring evidence that there was, then you would just change your vote to that there was. And it's not a new motion.
No, but that's the way you worded it is not the way we normally word our motions. It's we're voting for a violation of 6721.
Right. I am not a fan of creating motions to find no violation. The idea should be there's a violation. Do you agree that there's a violation or not? If there is no violation, then you would fail. That item would fail, and so there wouldn't be a positive outcome. It would just fail. Okay. You don't then create another motion to find in the opposite way. I've not argued this that much because people want the flow. There's a certain understanding in a certain way, but generally it makes it easier if there's just one motion on the floor and you either vote it up or you vote it down. But it's got to be, you're going to find a violation because that's what's being presented. And either you agree that there is a violation or not, you just vote it up or vote it down. That's it.
And I don't want to take too much time on this, but since I've been here, if there's no motion to find violation, we've been asking for a positive motion to find no violation.
So in general, if you fall back on Robert's rules, maybe I'm doing that too much, but if you fall back on Robert's rules, it would be if nobody brings a motion to the floor, the whole thing just dies. It's the whole item dies.
If we do it that way, then then this sentence, I guess, is, then the revote, then you are just, if we always go for the positive, is there a violation, yes or no, then if it's reconsidered, the change of that is fine.
The problem is because we're quasi-judicial, because we're kind of doing this thing, there has to be something. There has to be some closure. You got to say what that closure is. I don't think just by process, not bringing a motion to the floor is really the thing is. I think the whole case starts out with the question, okay? That's how it starts out. And when you get through the whole complaint process to the end, then you answer that question without your vote, yes or no. That's kind of the way I tend to walk into these things, because if I don't walk into a hearing, it's like, is there a violation? I keep asking myself that. Is there a violation? Is there a violation? Okay, I'm not just going to listen and then later figure out whether there is one.
So then the question is, do we only want one? The way you're describing order of determination, there's only one, no matter how many reconsiderations.
That's right. It's only one.
Wait, but so if the whole thing just dies, then there is no order of determination of no violation.
I'm not suggesting that we do that. I'm not in favor of no motion being on the floor. Okay. There has to, the complaint came forward. The complainant says, I believe that there's a violation of 6721 based on timeliness. That is that is essentially the motion. And after you get through the hearing, you get to the end, you say, you know what, there really wasn't any violation. So then on the motion that there was a violation of 6721, who's in favor? Okay, nobody. Who opposed? Everybody. Motion fails. And that's it. There's no finding of a violation.
And that's the order of determination.
That's the order of determination. The task force did not find in favor of the
So
complainant.
then do we want to limit it to one? Because your definition right now of order of determination is there's only one per case.
That's right.
So can there only be one request for reconsideration then?
Go ahead, Fiona.
So then right now, do we write orders of determination for every case because we vote up or down if we have a motion if there is no violation?
Right.
So we write orders of determination for every case.
We do it for everything.
Okay.
Right. So here, so my suggestion is that you start out with the question, which is the assumption that there's a violation. And then it's up to the respondent to prove that there wasn't a violation. And so there either is a violation or there isn't a violation. At the end, you answer that with your vote, yes or no. And if it's no, then the task force has found no violation.
So do we write ODs if there's no violation now?
No, you write ODs either way, and then you notate what the vote is.
Cool.
That's all. And that way, you only have one OD. Can only be a reconsideration on that one OD per case. And sometimes we do have 2 ODs per case, but it's for completely different bifurcated reasons. Like we want to send it to a special committee for special things or something like that. Yeah.
But then we have the issue that if nobody is in favor of the violation, then someone has to make a motion that they are going to vote against and they can't speak out against.
I think we've had with 6 people like here, it might be very well happen that we just keep going around in circles with these where we're unable to get a majority.
But remember, Ross, I'm saying even if we're all in agreement, we all agree there's no violation. Someone has to make a motion to say, I say there's a violation of 67.5, even though they're not going to vote for it.
I think it's not like you're in a deliberative body that's trying to make a decision whether to have a party or not. And you make a motion, should we have a party? Should we have it outside or should we have it inside? And that kind of thing. This is a little different. I think this is kind of like the assumption that comes in, the question that's on the floor when the case comes up is there a violation?
Yeah.
And the answer at the end is our vote,
Right,
yes
but
or no.
That's definitely the question, but that's not the way we
I understand.
we put motions out there.
That's what I'm saying is maybe we should not make a motion that the motion is implied. The motion is implied based upon the case, and we're just finding either in favor of the.
But don't our minutes still need to say who made the motion, who seconded?
I don't know that that's required. I mean, it may be in our bylaws, but I mean, we could adjust our procedure for making decisions.
I mean,
if it makes it easier for our work.
Or we could just make it so that the chair automatically makes the motion of the violation that's been alleged, and the vice chair automatically seconds it, and that's just rote process.
But if you run by Robert's rules, the maker and the second must vote in the positive every time.
They can't go about.
Can you make a motion that says, I move that we vote on this, as opposed to I move to find a violation?
Yes.
What are we voting on?
Can I say that I would say that I make a motion. This is not actually making a motion here, just for the record. But like, if I was to say the complainant has alleged a violation of a 67.2 thousand violation, I would like to make a motion that we vote on whether there is a violation or not, and the question shall be, is there a violation? A yes agrees with the violation, and no doesn't.
Does that allow you to vote against it?
I mean, we all then agree to vote on this, and we all vote yes. We're going to take a vote, and then we take the vote, and we all say no.
So are you suggesting
What? If we all disagree,
doesn't make sense. Twice?
Yes. So we make a motion to have a vote on a matter, and then we take the vote on the matter.
So what if there's a negative vote to vote on a matter?
Right.
I mean, so everybody's like, no, we're not going to vote on this.
So you see, if you think about it, and I think
the case is like acquitted.
I think
by lack of action.
Well, no, the case continues until you get a proper motion to carry to have the vote. Like basically debate continues until you successfully vote to end debate and vote on the question.
Yeah. So I understand. I'm thinking that it should be organized a little more like how court procedure is. Okay, because with court procedure there's an allegation, and then it's got to be proven by the defendant otherwise, right? So there isn't kind of like somebody making a motion. It begins with the allegation, and it ends with a decision whether there is one or there isn't one. Nobody has to make a motion for it. That is the hearing itself.
Except the judge kind of makes the motion to the jury, and then the jury deliberates on the motion.
I believe this is how the Board of Supervisors agenda is organized. The question is listed on the agenda, shall this motion be adopted? And they just vote on that. But the questions are already there.
Right, but who made that initial motion?
It is listed on the agenda.
So, but you can make
that person has to vote in the positive.
You can make a motion on vote on the question of, and then.
Well, that's basically calling the question.
Right.
Shall we vote? And so then it is on what question? Shall we vote on what?
Well, no. The question as presented in we could present in the packet, but I could say on.
But there has to be a requirement to vote.
Right.
Okay. That's what I'm saying is that I think at some point it's more of a question of, are we ready to vote? Okay, on this matter. Has everybody got enough information? So take out the part of I move and I second. Okay, just the item is already on the floor. Okay. So by the hearing beginning, when Victor calls the item now is on the floor. The question before us is this, and that way we're all free not to have to start out with a position of making a motion.
So it looks like the person who makes the motion actually can vote against it. They just can't argue against their own motion under Robert's Rules of Orders.
Okay. Fair enough. I would, in most deliberative bodies that I've been that uses Robert rules, they don't allow.
It's always frowned upon, but I'm doing some Googling right now. And
that's fine. I mean, like I said, I would say come up with something that people can feel comfortable with and that would fly. And that doesn't make things more complicated, because I found it too complicated to say, okay, if nobody's going to make a motion, or if somebody makes a motion and it fails, then there's got to be another motion. You know, it's kind of like what the Board of Supervisors does. They have 3 motions for a lot of items. If this item, you know, it's in the positive, it's in the negative, it's in some other thing, and it's weird. I understand why they do that, but it's weird. So I think it just gives everybody the benefit of either voting yes in one direction or yes in the other direction, kind of thing. So, all right, I don't know. I don't know that we've can come to a conclusion on this today. Shall we continue this discussion? People can sleep on it and think about it, and we can pick it up at the next meeting?
Bifurcated the issue from
yes, we have
to how are we going to vote on items? Well, so I can add that to the next agenda.
Yeah, I think the question becomes, it is like, how many orders of determination are there? Or should there be, because otherwise it runs the risk of, as you're suggesting, abuse, because people could reconsider any number of orders of determination that may come up in the course of one item. I would just say that you could also just separate it by motion. They're not really orders of determination until you agree. It comes down to some agreement at the end. You're just making motion. It fails, it doesn't fail, and then you finally come to one that passes. That's the order of determination. That's the one that's the static OD for that case.
We have no rule about making a new complaint about the same violation, or we do. So, like, there's the reconsideration option, but even if the reconsideration doesn't go through, they could just make another complaint, right?
We've
been tossing them.
Right.
I've been bringing the last Ray Hart's one was of that effect, but it made it to the task force for the task force to decide on that.
Right.
But if it is duplicative, I would give it to the complaint committee to make that determination.
Right.
And where is duplicative complaints addressed in our bylaws or the code?
Okay. I would need to think about that and get back to you.
Yeah.
Right. I'm curious where it's documented about duplicative requests. No urgency, obviously.
We have it in our bylaws.
I believe it'd be in the
Got to be the nucleus
procedures.
of operative facts.
It doesn't need to be now. We can move on.
I will look into that.
Okay.
But I think we have addressed it in the past.
Okay.
All good. You guys may have discussed it in the years that I was in here, prior to me coming on task force. I don't know.
I will provide look into that and get back to you.
All right.
I think it's important to remember that the Sunshine Task Force is not the only avenue for appealing public records things in the end, and that if we have a hearing on it and then we have a reconsideration on it and then they still don't like the outcome, or somebody doesn't like the outcome, there are other places for them to go.
Yeah.
There's a court. They could probably just take it to the Ethics Commission.
Right.
They go to the city attorney's office to get a different ruling. Like, it's not just so I don't know that we actually have to, if we said that we will only hear one reconsideration hearing per item, I think that's totally fair that we only ever do one reconsideration, because it only, after that order of determination comes in, after that 10 days, that's it. And we just, if people want to keep appealing, they got to take it to a courtroom. We just can't keep doing it.
You can actually put that in writing. Say if, you missed the deadline, you must use other resources.
Right.
Or something like that. You can do that. I would say, it doesn't sound like is there anything definitive here that people want to make?
I do want to list out exactly how the task force will conduct these reconsideration hearings. I believe that's been procedures for how to operate and the questions we should be asking.
Okay, I think that's
I believe that
important.
we've had problems with that with the Williams case.
Yeah.
I can draft something up for your review at the next meeting.
Okay. Yeah, I think absolutely we should figure out a definitive procedure for that. I agree.
Yeah, I think we need a process, and I think it would be good if somewhere right up front, the motion that was on the floor be read, so everybody knows what was being considered.
Yeah, I tend to like reconsiderations to be based upon the motion that was on the floor, because then it can't be yanked into other directions. So, now it becomes something else. An elephant doesn't become a tiger, that kind of thing. So it stays an elephant.
But I mean, I think tonight's case was an example that there was a change that we approved.
You mean the Clark case?
Yeah.
What was the change?
It was
we changed the
passive,
violation number.
Yeah, passive.
From passive to policy body.
Yes, and we changed the code section that was violated.
But
that's automatic.
Right, that's because it was a policy body.
Yeah, but that was the origins of the complaint anyway.
Right.
That's part and parcel to the original complaint.
And the new data that they presented were the emails that saying, yeah, this was created by the Full Arts Commission.
Right.
Yeah, I mean, I think it's part and parcel of the original complaint. Anyhow, I'm getting lost. It's late.
Okay.
We'll move on.
All right. So
Oh wait, we've lost quorum.
Yeah, but we just can't make any.
Okay.
You can have discussions, but you cannot make any decisions.
Because the meeting has
Which
already
we weren't
begun.
doing now.
That's just
Okay.
fine.
So, Victor, I guess we'll work on
A
putting
little
together
procedure, and I will
some
put it into
draft.
this document for the next meeting.
Right. But I think the idea of allowing any committee that hears complaints, or it could be just the complaint committee, to hear make a determination whether reconsideration is valid or not.
Yes.
I think that's worthwhile. Saves us a lot of time.
Yes, I added the portion where the committees would be allowed to make that determination. Is that acceptable?
We can't make a decision right now.
Mm-hmm. We'll put it off.
All right, we'll put it to the next one. The other item you had on the list was the rule of reason.
The who?
Rule of reason. And we haven't had that many respondents citing the rule of reason in a while.
What page are you on now?
That was on it was just on the agenda.
Okay.
There, it's just listed.
And then there was a draft from, I believe, Member Moss towards the end of that packet material.
There's a draft starts in 7:12. If I remember correctly, and if somebody remembers otherwise, please let me know. I think the position we were at is that I had written this up, but it really needed member 7:12. It starts under miscellaneous.
Yeah.
So was that maybe a member Testify was going to take a look at it because it required a certain legal analysis beyond what I had written.
And of course, DCA COLA can
as well
can do that to also help with that work. Okay, so we should push that forward. Okay, great. All right.
Are there no members of the public in the room?
No member of public in the room, so no public comment. Let's move to the next item.
Next on the agenda is item number 10, report from the Sunshine Ordinance Task Force committees.
Any committees have anything to report outside of hearing complaints?
We'll need to schedule an IT ad hoc committee for January or February.
Okay.
Depending on, I was going to say January until I realized that we were getting bottled up on other meetings for January.
Right. Okay, so we'll try to schedule those. Okay. Okay. No other committees have anything going on? Okay. We should talk about giving you guys some work.
Next
in your charge for your committee. Okay.
Next on the agenda is item number 11, the task force annual report.
Yeah, let's push on. I'm going to push that till next month.
Next on the agenda, item.
Resend it again.
Sorry? Resend the annual report? Yeah. Okay. We'll send it around again.
That's the official sunshine request right there.
Verbal.
Verbal.
10-day response time.
Immediately, please.
It's really a repetition because it's already been sent and it's been on this agenda so
Well,
many
then
times.
it's readily available.
So, there you go. All right.
Next on the
There's still
agenda
the
is the
assistance
chair's
component.
report.
Okay, so I don't have any action items, but I don't know if I sent, it was a little short notice, but I don't know if you guys had an opportunity to watch the playback of the Ethics Commission, where ethics staff had presented new changes to the regulations on show cause and enforcement. And so it based upon our discussion, a lot of this, the changes that came through there is based upon our discussion with Deputy Director Jessica Blome and Jeff Price, Investigator Jeff Price, who was here at our last meeting. And, sorry?
Actually vote on.
No, it was because we requested that they give us a month and that we asked them to give us till January. They agreed to do that.
Oh, I thought they had refused.
No, originally they did, but I think they
made some other changes.
They made some other changes. But an interesting question that actually I had a conversation with Jessica about trying to get to her just after our last meeting about this was that our insistence that we feel the enforcement process should be like a sentencing hearing and not re-adjudicating. She said that that's kind of impossible because of the way the law is written around enforcement. It gives the full authority of the Ethics Commission to, just like a court, to hear all the facts and evidence, provide for show cause, and all of that work. And so I think you'll get a lot of the meat of the discussion if you watch the playback and hear what Jessica is saying. But basically, she's basically saying and tried to explain to the Ethics Commission that when an OD is presented for referral, that there should be some kind of conference between either the chair, a ethics commissioner, or staff to go through the findings of fact, basically. They don't consider our orders of determination to have any standing of law. They're not conclusions of law. That's, in her words, she does not believe that at all. I wanted Luam to be in on a meeting. She was very strong about that. I'm going to arrange a meeting with Jessica and myself and Luam so we can hash that out. The problem that Jessica's having over there, or they are, is their legal counsel is not willing to participate in providing any information on this. They don't want to be part of it. So they're all lawyers, and the staff are mostly lawyers. So I don't know. We'll have to have some discussion. I've asked DCA COLA to take a look at some of the points that we made at our last, and I would urge you to also watch that section. Commissioner Rennie did ask, is there a rule or a law that requires them to take our orders of determination as a finding of fact, which means that they could not challenge it. They would have to accept it wholesale. And nobody could answer that question. Not even the deputy city attorney for the Ethics Commission. So that's kind of up in the air. So that's another discussion with staff to have. The other one was Commissioner Kopp had asked for us to provide a reason why we feel that they should only be the enforcement arm and not re-adjudicate. He wants a reason from us. He hears that we have concerns about it. He wants to know what those concerns are. And I've expressed that to Jessica, that if they were to find opposite or different than our orders of determination, it wasn't an enhancement of it in some kind of way, then it's more or less like an appeals court. They either agree with us or they don't agree with us. And then the question is where does that leave us in credibility? Right. This is not, we're not part of the judicial system where those particular courts exist, whether they're right or wrong. So go ahead.
So it seems like as the city charter empowers us to find violations.
Not the city charter per se. It's the Sunshine Ordinance.
Which is in the city charter.
No, it's not. It's in the administrative code.
Okay.
It's not part of the charter.
Sorry. Under the city code. Did not mean to.
That's all right.
Squish
making
those.
it clarify.
Thank you. Under the city code, we are empowered to find violations of the Sunshine Ordinance and the state open records law. So if we find these violations and then the Ethics Commission, which isn't explicitly empowered to identify those violations.
They are independently.
Explicitly?
Yes, explicitly.
Any person may institute proceedings for enforcement penalties under this act in any court of competent jurisdiction or before the Ethics Commission.
Yeah, no. But they can receive. They in the ethics code. They are allowed to receive natively sunshine complaints.
So sunshine complaints could go directly through ethics and not through us at all.
That's right. And so that's why in 2012 we started this process of what happens when there should be a difference in the way Sunshine Ordinance Task Force referrals are processed for enforcement versus when a native complaint comes to them.
Right. I did not realize that both of us are explicitly empowered to take on that role because I had a better argument until that worked.
Right, but Jessica was pretty clear that she says that unless you have enforcement power, your power or authority to find facts is purely an opinion. Had she just plainly said it that way? It's really just an opinion. And I said, well, then that's no different than your investigative department, except your investigative department does it in secret and we do it in public. And they can take a lot more time to do investigations. They have subpoena power. They've all kinds of other kinds of law enforcement type of authority, and we don't. So she says it's a show cause. It's basically a show. What you do is their show cause hearing. It's just public versus staff presenting a recommendation for a violation in violation of the Fair Political Practices or the Ethics Code or something like that. So it's a little complicated, and it kind of pulls us like silly putty in one way or another. But I think we need to have a little more conversation about it. Unfortunately, are we having another meeting before
it is my hope that we would have a meeting on January 18th. I believe they now meet on Fridays, the third Friday of the month.
Right. So if we can get another meeting and have another discussion on this and figure out, these points, and have that meeting with Jessica and Luam, a member testify, and Deputy Director Blome, and kind of hash out some of these gory details, and we'll bring something back. We'll figure something out. And either Jessica will say, you're right, and I'm going to make those adjustments. She'll do it on her end, that kind of thing. But I think we still hold that we would like, the thing she said is if they don't agree, they would probably remand it back to us with their concerns or their feelings on it.
But then it could become a circle.
That's right, but that's how isn't that how the court system works, more or less? It keeps, you go from one to the other to the other to the other until you finally get.
But there's a properly clear hierarchy in the court
I understand that, but this is trying to get to agreement that there's a violation that enforcement can be applied. And we don't want, either of us don't want to step on each other's toes for it.
Have they agreed, or was it discussed having us send them cases that are not willful?
Yes, that's the whole point of this whole thing. And as Member Moss had just read, I think that was, 6735? And 6730? Yeah. The task force shall make referrals to a municipal office with enforcement power under this ordinance or under the California Public Records Act and the Brown Act whenever it concludes that a person has violated any provision of this ordinance or the acts. Okay? That's where Deputy Director Blum came to us with that. Okay? We have not exercised that in all these years that it's been there. It's not been exercised. So the point here is if we find that, for instance, and its scenario could be there are multiple violations. Okay? We keep sending them because we start seeing that there's this pattern, the same person violating the ordinance for these same particular things. Okay? Now they've got a pile of them. They could say, wow, same person, that we better find out if this is willful or not. They can then make the decision whether it's willful, and they've got actual evidence for it, and they can do that or not, or levy them pretty heavily. And they said they could enforce penalties up to $5,000 per violation. So multiple violations.
I would like just to caution that it looks like their meeting would be on January the 19th, which is the third Friday. Our meeting, if we choose to, would be on January the 16th. We would not have time to provide any written documents for their packet, and I believe they were very clear they want any recommendations from us in their packet.
Right. So I think the thing is I think we know what we want, and if they're willing to do that, I think if we can authorize myself to, if they fit all our, one or more of our conditions that we want, to allow them to, give them an agreement that will, that we agree with that officially. You can do something like that if you want.
I believe you were previously authorized to send a memo to the Ethics Commission regarding our last batch of recommendations from our last meeting.
Right. But those are things that we voted on.
Yes.
Okay. So it's just the authority to communicate. This is something different. This is authority to negotiate. So it's up to you folks if you want.
I'll make a motion to give our chair the authority to negotiate with the Ethics Commission staff. Is that right?
Yeah.
Yeah.
Well, the Ethics Commission, because that includes their staff.
But who are you? Are you negotiating with the commissioners or the staff? Because the commissioners would happen in the meeting itself, right?
The staff. Well, you could do it for the staff, but the staff are the agents of the commissioners. But you're right. It's not clear whether they would agree to any of this or not.
But I think that the commissioners would make a decision, and that would happen in a meeting, right?
Right, that's correct.
So I think authorizing you to negotiate with the commission staff, and then the meeting itself, I'm not sure that we shouldn't all choose to go.
Yes.
Yeah. So,
I agree.
Yeah, I would like to make a motion to authorize you to negotiate with the staff of the Ethics Commission.
Based upon our previous
Exactly.
points. Okay.
Second.
Okay, so moved by member Josh Wolf, second by member Hensy. Any further discussion on this? Member Moss?
So I'm just reading through the SF Gov TV transcript. So we had tried to describe, at the last meeting we had thought of the Ethics Commission as a sort of sentencing hearing. Right. They seem to be viewing themselves as an appellate court in the.
That was a
suggestion. Okay, so but that's.
Yeah.
I haven't gotten that far yet. I'm trying to work through it, but.
They're not quite sure.
Okay.
That was a question that came up, is whether they, so then we are an appellate court then, right? And that was kind of put out there.
Okay.
Yep. The problem is this enforcement thing gives them, full authority to adjudicate it. What the ordinance provides us in finding violations and then making referral bifurcates that authority. Jessica is basically saying that there's some, I don't know whether it's in court procedure law or I don't know, there was some section of law that she put in there, and then there was something in the charter. So I'm not I don't have the full.
But the thing is that an appellate court is always like broached by the losing party, and in this case,
right,
this is the court referring it to a higher court. So it's not. It may be a higher court, but it's not an appellate.
It's where again, I tend to want to think about it as a sentencing court.
I don't disagree with that.
Yeah, yes, they don't consider us a court because we can't sentence.
Right.
Right.
That's right. So they see us as just finding a fact.
So we're like drug court.
Not conclusion of law.
We're like drug court, and then we refer it to superior court.
That's right.
I mean, isn't this sort of a natural bureaucratic metaphor that...
I think I got it.
Ultimately should be shaped by voters, but it's not.
That's right, and that's why they're...
really in the position...
That's why almost every single former chair of the Sunshine Task Force is writing amendments to the ordinance to clarify.
I mean, they're just they want to maximize their bureaucratic power versus.
That's right. That's right.
Naturally, you want the same thing. We would like more teeth.
That's right. So, okay. With that, can we take that by acclamation?
Yeah.
Seeing no objection, motion passes. Okay. I don't have anything else unless we want to talk about. We could do it under my report, the behest of payment.
I mean, the only thing
opinion.
on the behest of payment thing is that the city attorney and the district attorney concurred with the Ethics Commission. Just to give some clarity on it, so the opinion that you have there, as I understand it, and maybe DCA Cola can jump in if I'm going too far here, the opinion says that the Sunshine Task Force is not covered by the behested ordinance. And that is something that you can rely upon because both the city attorney and the district attorney have concurred with this. What I had said the last time is that on the issue of specific immunity to the individual, that only applies to me because I had described my personal circumstances to them and they were able to make a judgment based on that. So your personal circumstances may be different because maybe you also sit on the Planning Commission, in which case you would also be subjected to the behested ordinance and you could not get immunity in the same way. I don't think you need to apply for immunity. I mean, that you can ask DCA Cola about that. I think the opinion's pretty clear. That said, again, there's another behested ordinance coming that we all need to worry about. So,
right, that one I've been watching pretty closely and actually working on it. Actually spoken publicly about many parts of that one. But that one is an interesting animal. That one's going to go before the Board of Supervisors very soon. I don't know. It should be on their next agenda or one after that, because they're trying to beat the deadline to put it on the ballot if they don't like the outcome from the Board of Supervisors. And I think every nonprofit in the city is going to raise their arms in that. It's the Ethics Commission, but there's a group that helped sponsor it called the Friends of Ethics. And they, normally they come up with, pretty good things. This one, it's a little overreaching because if you listen to all the past hearings from the Ethics Commission, they talk about Airbnb and the front groups, from them and Uber and that kind of thing, the corporate-backed nonprofits. They're not talking about charitable, public benefit nonprofits. And when you look in the room, that's who's there. Those other folks aren't there. So it's kind of like, they're basically saying by constitutional law they cannot isolate or discriminate any one group. And I disagree with that because it's almost everywhere in law there's some discrimination over one group or another in some kind of way for something. The laws in the 501c, there are like 30 different classifications, and there's different laws for each one of them. But they're still all corporations.
This isn't an action item, though, right?
No, this is a report.
Okay.
Just to let you know that if you serve
Because I've done work for Friends of Ethics, and so I'm trying to figure out potential recusal issues if necessary, but there's no action items.
Well,
so
no,
I can just
there's
sit here right now.
no action items. The thing about it is this new set had started out with some bans.
Right.
Okay,
I just now learned that Friends of Ethics was connected to this and was like, I did work on their website, so I don't know what to do.
Yeah, well, yeah, right. Anyway, so I would urge you to watch the proceedings at the Ethics Commission. I think it was very informative. Their discussion about it, I thought, was very good. They weren't necessarily calling us names, through it or anything like that.
At this last Ethics Commission, they weren't?
Yeah, not
no, because they did it the previous one. I'll say that. I think they were not referring to us. I think they may have been referring to complainants as screwballs, but they did refer to us as a multi-headed hydra.
Right.
90% of what we do is BS. That kind of thing. So yeah, they did. They did say some.
Right. I just
should not discuss that.
Lastly, my only concern with regards to the changes in their regulations is that they don't usurp us. That's really a big concern because there are a lot of people that would prefer this body be dissolved and go away.
And they did raise that was something that was at my hearing that they had discussed. Yes.
So.
Except the Ethics Commission doesn't want to hear all the complaints we hear. So
that was why they took it off the menu of things they were discussing, is because they did not want to have to deal with the 90% of BS that we deal with.
If you were to ask their investigative unit how they would go about investigating or showing cause for it, is, by the time it got to the commission, they would have muscled it down into its very smallest, coarest parts so they wouldn't have to have, full-on discussion. Thank you, DCA Cola. Have a good holiday. So anyway, that's that point. All right, that's all I got. Let's move on. I want to get home.
Next on the agenda is Administrator's Report. The Education Outreach Training Committee for the 19th is canceled. The December 26th Committee for Complaints is canceled. And it is my understanding that we are going to cancel the January 3rd meeting of the task force due to lack of quorum. And my suggestion is that we have a special meeting on the 16th, as I believe we do have enough people willing to attend on that date, in place of the Compliance and Amendments Committee.
Oh, but then what happens to the Williams case?
I have a meeting on. I have an open date on January the 30th, as it's the 5th Tuesday, and all the rooms in the City Hall are usually open on the 5th Tuesday.
Okay.
If that's agreeable.
Magical day. That's according to my calendar. That's fine by me. Now,
Member Moss.
I would need to check my calendar. Get back.
Okay.
Who's the third member of your?
Island.
Oh, okay.
But I could probably.
Yes, and there are 4 compliance issues now.
Nice.
We had 3 previous compliance issues to hear, and now there will be 4. And hopefully I can throw in 1 complaint just to fill your agenda and get some work done. As you can tell, is that acceptable? The January 30th, I can work on that.
That's fine. Yeah.
And then is the 16th date acceptable as a special meeting date for the task force?
It's fine by me.
I will send that out and confirm with everyone tomorrow.
So EOTC is just meeting next in February?
Yes. We have quite a few new complaints this month. We will schedule them as soon as possible. In terms, we have 2 pending issues that I just wanted to remind the task force about. Actually, we can talk about that, but we have 2 pending issues under item 5 that we do need to schedule hearings for. That would be the Ray Hart's city librarian regarding the 67.26. We're going to bring in some outside experts to talk about the issue.
Yeah, that's the one where the word ordinance we say means the whole Sunshine Ordinance, and they're saying means just 67.26.
Oh, right.
Yes.
Oh, God.
We said we were going to bring in experts, so
How can you not remember that one?
we do need to eventually organize that.
Yeah, that's fine.
I don't think I was here for that one.
Yes, you were.
I was?
No, he wasn't.
No?
I don't think I was.
You were here for one of them. This has come up a few times.
Yeah, this is I think you were here because we brought that back here, and then we had a hold. You were here. I remember you very clearly discussing this in depth, and we decided to continue.
And then we couldn't decide on how to rule. It was the matter of interpreting what that section meant.
And you wanted to bring in some of the original founding fathers of the
so
Sunshine
this
Ordinance.
was the 6721.
Oh wait,
No,
wait.
This was that a third party, Friends of the Library, raising funds. That all started because there was never an agreement between the library and Friends. So we asked them to have an agreement, and in that agreement to stipulate that they will have to be required by law, by the Sunshine Ordinance, because it says so in 67.26. So they took that and they read 67.26, where the word ordinance came up. They said, it only applies to 67.26.
Oh, jeez.
Yeah.
Oh, and not the whole.
And not the whole ordinance, right.
The other one we had on 6721 was whether somebody other than the actual person
that's the other one.
was requested, the actual custodian could actually do the work.
Yeah, we discussed that in the earlier meeting this month, right?
And that one's still out for discussion.
Victor, what's this chart here in the admin notes?
Oh, sorry.
Oh, okay, that's what that is.
You're reading my notes to the committee.
Oh, that's what that is. Oh, yeah.
Yes, it's the results of the poll for the meeting.
Okay, got it.
Is that it for you?
Yes, it is.
Okay, is there a motion to adjourn?
Yes, so moved.
And there's no public comment on announcements.
Yeah, no public for any of this. Moved by Member Kanata, second by Member Josh Wolf. All those in favor?
Acclamation, aye.
Okay, we are adjourned.